I'm going to call to order the hearing for today, March 10th, 2026, but we're going to start with the continuation of the protest hearing in reference to the Magothy Inn. And then Mr. Hurdle, if you would.
Thank you, Mr. Chairman. This is a continuation of the hearing that was scheduled in February. The last time we were here, the petitioners had rested and the questions were with Mr. Bittner. We're going to turn it over to Mr. Bittner. We have an hour and a half till 5:30 to wrap this up. Mr. Bittner, I anticipate that we'll probably give you about an hour for your case. We'll see what we can do.
Thank you.
Thank you, Mr. Bittner.
No, certainly, and I appreciate that, and good afternoon, Mr. Chair and members of the board. We will certainly be as efficient with the board's time as possible, and I believe you're correct. We were at the juncture where I was to begin questioning Ms. Taylor.
Correct.
Thank you. So, ma'am, how long have you lived next to the Magothy Inn?
I'm happy to repeat my answer, but we did do that in the interest of time.
Happy
to repeat it. Okay, no problem. I moved in 5 years ago, and the 5 years before that, I spent extensive time there as I was dating my husband at that point.
So you've been well acquainted with the Magothy Inn for 10 years?
I would not call myself acquainted with it, but
How would you describe
generally,
it?
I don't know. I'm not sure. I know it's there. I didn't want to imply that I think I've been in it once. I don't know what it's like inside. I don't want to imply that I have more knowledge than I do.
Okay. And your knowledge of the Magothy Inn is what you previously testified about, is that right?
Sure.
Okay. And the Magothy Inn, would you agree with me, is when you first became aware of it some 10 years ago, was more or less in the same condition as it exists today?
No. No.
Right? Being open and operating for the 10 years since you first became aware of its existence.
I'm sorry? I don't
But it's
understand
been
the question.
open and operating.
Oh, I knew it was in operation, yes.
Okay. All right, thank you. I don't have any other questions.
Sorry. I believe at this time, the case is with you, Mr. Bittner.
Mr. Hurd, I'm not sure that's quite correct. May I?
Please elaborate.
If my memory serves me, I think Mr. Taylor called Catherine as his first witness in his case in chief. And if I go back before that, we went first, we being Catherine. Our only witness was Dave Phipps, went on to Todd. Todd's first witness was Catherine. I don't know if Todd's got any additional witnesses in his case. I know at the beginning of his examination of Catherine, the board seemed to suggest that if Todd had any facts he would like to represent to the board on his own account, he may be free to do so, but I think it might still be Todd's
We'll
case.
turn it over to Mr. Taylor.
I think that's correct, yeah. No objection, yes.
Okay. I would like to call Regina Miller, please.
Ma'am, have you been sworn in yet?
Before, not now. Last time we were
Last
here.
time.
Yes.
Did you swear her in?
I'm not certain. There were a lot of people that were standing up swearing in at that time. Would you mind being sworn in again?
Yeah.
Okay. Can you please stand up and raise your right hand for me? Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You can please be seated.
So, Gina, where do you live?
542 Center Street, Pasadena, Maryland, 21122.
And when did you first move into that house?
29 years ago.
What is the approximate distance between the bar building and your property? About 50 to 60 feet.
I think about 60 feet.
And are you an owner of the home or a
Yes, I
renter?
am.
So I would like to offer Exhibit 131, and for time convenience, can I also offer Exhibit 132? These are going to be presented together.
Mr. Bittner, do you have any objection?
These are part of the administrative record.
I mean, they may well and good be part of the administrative record. They're from 1988.
I'm going to admit them, but they're going to go to wait.
Thank you.
Mr. Taylor, I'm just going to remind you that this is for the renewal period that ended last year.
Understood.
Do you need these copies?
I'm sorry.
Do you need these?
Those were, I'm sorry. Those were for the board.
Okay, got your own? You have your own copies?
Yes, I do. I'm sorry. I'm sorry. Actually, I do not. I think one of them is in that, please.
Can we get one copy
Yeah,
of
can we
each?
get one copy of those?
I don't need them. We can just give them out. Thank you.
131. Okay, so looking at Exhibit 131, can you tell me what this document is here, please?
This document is directing that Paul's supposed to put up a privacy fence in 1988.
And then I'd have you look at Exhibit 132. Now, this is a supplemental report that came out the week prior to that letter being issued by the board that required.
So I'm going to object to the reading to evidence that speaks for itself.
I'm going to sustain the objection, Mr. Taylor.
Okay. So has the bar ever built a fence required by both the board and Office of Planning and Zoning?
No, just a chain link fence.
And what are the consequences of not having that fence?
Exhaust fumes from the vehicles that's backing up to my house. It comes in upstairs, goes into my dining room. The patrons also feed my dogs, so my dog is getting out of the fence, and I'm responsible for that. There's the music. Sometimes it's very loud outside. You can hear it when they open the back door. You can hear the music coming in. I can also hear music when I'm outside hanging clothes during the day from inside the bar without the doors being open. You can hear people talking and arguing outside the bar at 1:30, 10 o'clock at night. I don't appreciate the arguing or the slamming of the doors. Quiet. You can always shut the doors quietly. You don't need to slam the doors. There was a hit and run about a month ago. Someone left the bar and I was outside. I saw a truck hit another truck and didn't even stop. Just kept on going. People leave the bar and they pull out of the bar and they zoom up Center Street fast. My granddaughter was out in it twice. This happened to me. And I think if I had a privacy fence and if someone can watch their patrons leaving the bar, maybe that would stop.
So based on your personal observations, has the noise from the bar increased over the last 5 years?
Yes.
In what way is it noisier?
They're getting more clientele coming in. They're parking along Center Street, so you can't go out of Center Street in case you need an emergency. It's blocked. The music's loud. The people are loud. They're not. They don't have any respect for people that live next door to the bar. They have the radios going on in the car at 1 o'clock in the morning. They have, they leave the cars running. I don't know if they turn the cars on at night when they're inside the bar, but you can hear the cars running at night. My bedroom window's right next to the bar. I can't change that. That's the way the house is built. So you can hear people in and out coming into the parking lot, slamming their doors, yelling, "I'll see you next time," or whatever.
Okay, and how do these sleep interruptions affect your family?
I have
I'm sorry, I didn't hear that question.
I was asking how the sleep interruptions affect her family.
I have a 7-year-old great-granddaughter, I have a 16-year-old granddaughter, and a 26-year-old granddaughter. They all live in my house. And they can't sleep because either the clients are being noisy or they're arguing outside, or they're zooming around the parking lot, going up Center Street like they're racing.
And how often does this occur?
The racing on the cars happens during the day and at night. People lose control of the cars also when they leave the bar. There's two incidents that happened. One was across the street from me, but that was Paul's brother. He was sick, and he hit the fence across the street. I mean, a tree across the street from me. And then coming out of the bar another
I'm sorry,
time.
the driver was sick.
Yes, he was sick. I didn't realize that. That was Frank.
When the bar's door opens, do you hear the music become noticeably louder than when they are closed?
Yes.
Have you ever witnessed fights in your own front yard between bar customers?
Yes.
In the last 2 years, where does the noise come from most often?
Well, now they had that deck built on. You can hear the people outside at night. And the music's loud because they have the doors open or they have speakers going on. I'm not sure if it's a baseball game on. They have the TV outside and you can hear the TV, people yelling and screaming. And then recently the door's been closed, so I don't hear too much noise, and there's nobody on the deck. But you can hear it when they open and shut in the side door. There's two side doors, and you can hear them talking when they open and shut the door.
Has a vehicle ever entered your front yard upon leaving the bar's parking lot?
One time, that was in 1988.
How long do some of the disturbances in the parking lot last?
Sometimes 20 minutes, sometimes 5 minutes. It all depends on the person.
Have you ever seen any bar staff come into the parking lot to quiet loud customers?
No,
Have you ever seen bar staff patrolling the parking area?
no,
Have bar staff ever communicated or initiated communication with you regarding your complaints or concerns?
no.
Are you able to clearly hear and understand what customers are saying while they are in the parking lot and outdoor service
Yes,
area?
you can.
Can you hear them from inside of your house?
Yes, you can.
What kind of things do you hear?
You can hear them saying goodbye, see you later, or they argue, and I try not to go out because I'm by myself. There's no men in my house, so I stay in my house. But you can still hear them fighting, and you can hear cussing and stuff like that. So
You identify that you have children in your house. What is
Yes.
the age of the youngest?
7.
How does it affect your family when children in your home can hear obscene language or inappropriate conversations coming from the premises?
The 7-year-old gets scared.
Have you ever personally observed any septic overflows on the tavern's property?
That's a long time ago, once, before they had the blacktop, before they blacktopped the parking lot.
I'll have to come back to that one. Okay, so tell us what happened on Easter of 2024.
My daughter had gotten into a fight with her husband.
If I may, Mr. Taylor, we're only interested in the time period that went from May of '24 to renewal of '25.
Okay, this is March of 2024. What is it? I think
That's
it's March
before the
31st.
renewal.
Okay, so even a 2-week period. Okay, fine. Did Paul engage in any conduct towards your family that you perceive as threatening?
Objection, I thought you just ruled.
I'm sorry, I was not referring to that specific incident, just at large.
I'm going to object to the at-large nature.
Mr. Taylor, we have an hour and a half to finish this hearing.
Mr. Hurdle, I understand that, and I'm just simply trying to address questions. Keep in mind that you were expecting to hear from at least 10 protestants in one of these hearings. So, I mean, I do think you have to at least give us enough time to at least have 3 people providing their own testimony who are protestants.
Please continue.
Okay. So please tell us what happened.
Objection, tell us
sorry.
what happened when.
I'm sorry. So has Paul ever threatened any members of your family?
Yes.
Please tell us what has happened.
I was arrested for threatening my son, my stepson.
Objection again to the time frame and relevancy.
Okay.
I'm going to sustain the objection.
Okay. Let's see here. In the summer of 2024, did you place traffic cones and markers along the edge of your property after it was surveyed?
Yes,
Did you hear the police instruct Mr. Page not to destroy your markers?
yes,
After that, did Mr. Page drive over the cones and markers and destroy them?
yes,
Have you ever felt intimidated by the licensee, staff, or patrons?
yes,
Have you ever
Minimum
withheld
object,
or
move to
delayed?
strike on the ever. Have you ever?
Sustained.
Okay. Have you, have there ever been any incidents where you have felt intimidated by the licensee?
Objection to the form of the question.
Have you withheld or delayed filing complaints with the board?
yes, I have.
Again, form of the question.
We
I
need a
have
time frame, Mr. Taylor, for these
I understand.
questions.
Okay, I have no further questions for Mrs. Miller.
Mr. Bittner?
Ms. Miller, I believe you said that recently the door to the establishment has been closed and you don't hear much. Understand that?
Yes,
I don't have any other questions.
Mr. Hurdle, may I be in touch?
Please.
Thank you. I'll be brief. Ms. Miller, you stated your homes, your bedroom window is directly next to the establishment. Is that
Yes.
correct? Within the period of 2024 to 2025, would a privacy fence between that window and the establishment remediated some of the issues that you told the board about
Yes.
this evening? And is that fence the same fence that was required by the documents
Yes.
Mr. Todd showed you just a moment ago?
yes,
And is it true that the only existing fence between the establishment and your family's home is a chain link fence?
yes.
That's all I have. Thank you.
Mr. Taylor?
Okay. So I would like to go ahead and just provide my own testimony at this point in time. Okay. So to begin my testimony, I'd like to expand on the conversation that my wife has already testified to and that you asked me to speak to the details from that conversation that you wanted me to address directly.
If you were there personally,
Yes, I was there personally. So at the point in time of this conversation, I had not had any interactions with the licensee before this conversation. Mr. Page, he approached me in my yard while I was doing yard work, and he asked me if I had filed a complaint with the liquor board a couple days prior. Now, I told him that I had not.
So I didn't get a time frame on this.
Sorry, I'm picking up from the conversation from the, that was already discussed in the previous hearing session.
was this during the renewal year?
This was in the 2023 hearing. Or sorry, during the, it was in the 2023 year.
So from May 1st of '24 through April 30th of 2025.
This is prior, this is in between, I think this was like May 30th, May 28th, somewhere in that ballpark of 2023.
Sorry, Mr. Taylor. This isn't for this period of renewal.
Well, I understand, but this is going to set a foundation for the things that come after, as this has direct, this is going to speak to a pattern that the licensee and how it is that he addresses.
Why don't you
complaints.
address the issues that occurred during the renewal period from May 1st of '24?
I understand. Well, this is going to speak to the pattern that I'm about to give you for 2024 specifically.
We don't want to hear about a pattern from this started before. We want to hear about the things that occurred during the license year that you're protesting.
Okay. Well, in 2024, I was confronted on 3 different occasions by 3 different patrons in front of my home that I observed coming over directly from the tavern. Now, on 2 of those occasions, the individuals, they had approached me and threatened that they were going to block my ability to park in front of my own house in my own yard using the same language that Mr. Page had used in the previous year to make the same statements. Now, there was also another.
Just for the record, preserving.
For the record, please continue, Mr. Taylor.
Okay, so there was also another patron who had driven over to my house. He was recording video and telling me that he didn't like what it was that he was hearing at the tavern. Now, I also had contractors who were working in my yard that year. They told me that they had had patrons walk up to them, recording video, and were also saying unusual things to them. Now, also in the summer of 2024, while walking through the community with my wife, I had another gentleman approach me, and when he asked me if I lived next to the tavern,
Hearsay.
I haven't said anything.
Mr. Taylor was there in this administrative hearing, Mr. Bittner. Please continue, Mr. Taylor.
So then he approached me. I identified that I lived next to the tavern, and then he told me that that he and some other nebulous group at the tavern were going to run us out of town. So I'd then like to move on to talk about some things that happened during the fall of 2024. So there were a few weeks where I was working in a different part of my house in the evening than I typically do. And as a result of that, I was able to hear other noises coming from outside that I typically don't. So during that time frame, I ended up looking out the window. If I saw patrons urinating out in the parking lot, I would start recording. So I ended up manually recording in that few-week period of time frame 4 separate urination incidents. 3 of those videos were submitted to the board. I had witnessed 2 other urinations when I was not in a position to actually make recording in that fall. And to orient the board, these urinations, they were not occurring in some sort of back parking lot. These were occurring directly in front of the tavern, and they were happening within 30 feet of the main road that runs through our community, making them plainly visible to anyone who passes by. So I'd like to offer Exhibit 9. So now I'll just give a second here.
Need that back. Please.
Mr. Bittner, any objections?
No, sorry.
So this exhibit, it shows the tavern's response to receiving complaints about urination.
Objection, its document speaks for itself.
Well,
Mr. Taylor, you can continue.
all right. On page 1, it is an email from the tavern manager to the chief inspector. It states that the staff will tell all new customers there is a problem with the neighbor. Now, the communication does not address the underlying urination. It instead characterizes the situation as a problem with the neighbor. If you turn to page 2, is another email from the tavern manager to the chief inspector. Now, after reviewing the urination footage, the manager asked him, did she set this up? Now, the manager did not address the conduct shown in the footage. Instead, she questions whether the urination has been staged by a neighbor. I'm going to go ahead and just give you another exhibit. I would like to offer Exhibit 25, please.
Mr. Bittner, any objection?
No.
Please continue, Mr. Taylor.
So the exhibit should be already open to page 3. So it is a post on the Magazine's Facebook page by a staff member in response to 2 urination videos that were submitted for a different night. Now, this staff member publicly claimed there was 0 evidence and accused neighbors of making false accusations. Yet one of those videos, it shows
Relevancy.
I think it's direct.
Overruled, Mr. Bittner.
So it shows a patron not only urinating on our fence, but he's slurring his words and he's holding onto the fence to keep his balance. Now, directly behind him in the shot, you can see another patron who is urinating just 20 feet outside of the tavern's front door, both without any sort of staff intervention. Now, despite this video, the staff member in the post says the neighbor's complaints are false and then publicly labels them as bottom rung individuals. Now, these exhibits, they show that the urination was documented and reviewed by the manager. However, the staff publicly deny the urinations occurred, and the neighbors are publicly blamed as the problem. So I had told Mr. Page in that 2023 conversation that I was the person who set up the cameras. And Mr. Page knows that the same families that live next to the tavern now are the same families that lived next to the tavern before his father purchased it. And yet we will see that in all these Facebook posts that his staff continue to tell both the board and patrons that the neighbors are new, that they are renters, that they are fabricating complaints just to get the tavern shut down, and the list goes on. Now, at any time, Mr. Page, he could have corrected these false statements, and yet there's no evidence that Mr. Page has attempted to address any of the posts that his staff have made, and his staff's incorrect statements continue. So after the last urination video I submitted to the board.
I'm sorry, what was that date again?
I'm sorry, which date are you referring
The
to?
last urination video, the date of that urination.
Not exactly sure. Let's see here. Let me look. I can probably tell you if I look at the video footage itself. Let's see. It's going to, unfortunately, I can't give you the exact date at the moment. It is like 9/28. I want to say it's right in that time frame, give or take a day.
So roughly late September of 24.
24, that is correct. So after the last urination video that I submitted to the board, the chief inspector at the time, he told me that he had spoken to the licensee's representative and that a camera was going to be installed in the problem urination area. Now, within 3 weeks, there were 2 new cameras that were installed on the tavern. However, these cameras were pointing at neighboring properties. No camera was actually installed in the problem urination area for another 5 months. It was only done just a couple of weeks prior to the 2025 scheduled protest renewal hearing. So I'm going to, well, I think that what matters here is how the licensee responds when the misconduct is brought to his attention. I mean, when documented behavior is both denied, minimized, and redirected onto neighbors rather than being corrected, the licensee's response goes directly to fitness under 4210B12. I wanted to address the parking lot. So neighbors submitted complaints on multiple dates about a motorcyclist who would sit in the parking lot during the quiet hours. He would rev his engine repeatedly.
Just for the record, time frame, Judge.
Sorry, what is the time frame?
Relevancy.
Did this occur during the renewal
Yes,
year?
this occurred during the renewal year. He would blast music and he would repeatedly rev his engine. Now, the tavern informed the chief inspector they had the issue resolved. However, on inspector's next visit, he observed the same conduct that was reported to the complaints. So violation notice 1278 was issued. Now, this matter did not make it to a hearing due to the inspector's employment with the board being terminated. And no notice was really reissued. I'm just looking here to see. I'm going to give. I'd like to offer both exhibits 22 and 23 at the same time. I'm really only going to just say one line about exhibit 22.
Mr. Bittner? Mr. Taylor?
Just for the record, I mean, I don't know what these are, the relevancy, there's no foundation.
We're going to admit them and just have them go to wait.
So after a violation notice 1278 was issued, in exhibit 22, staff invite people to come by and express your gratitude to neighbors on behalf of the tavern. And then in exhibit 23, on page 21, staff offer a free round of drinks to anyone who arrived on a motorcycle. Now, the neighbors didn't raise issues about motorcycles. It was about repeated noise disturbances during the quiet hours. Now, I have also personally, during this license year, observed numerous other noise disturbances in the parking lot during the quiet hours, including physical altercations between patrons, prolonged yelling between patrons at different ends of the parking lot, and loud music coming from cars that will sit there for prolonged periods of time. Now, on all these occasions, I have not observed any staff intervention. So on July 25th of 2024, a surveyed marker was laid down on both the neighbors as well as tavern's boundaries. Now, the following day, neighbors ran string lines along the surveyed boundary. Police were called to the tavern the same day that the markers were placed, and I personally observed a police officer instruct Mr. Page not to destroy the string lines marking the surveyed boundaries. Now, despite this, Mr. Page destroyed 17 string line cones and 3
Objection
traffic
to the
cones.
characterization as well as the relevancy.
Well, I mean, I can provide video footage if the board wants to actually see what destruction looks like.
I'm going to overrule your objection, Mr. Bittner. Please continue, Mr. Taylor.
So within a 1 month period of time, he had basically won over the cones repeatedly. So shortly after the string line was put up, posts appeared on Facebook from the tavern staff. So on that same exhibit, that was 23, was one of the last one I turned in. So if you look further at that exhibit 23, it contains social media responses from staff members. When someone suggested running over boundary cones, staff replied, "Feel free." When retaliation was mentioned, another staff member said, "I love the way you think." And when disruptive motorcycle activity was proposed, a staff member joined in with, "Tonight's a good night for a ride." So I'd like to offer exhibit 26.
Mr. Taylor, I'm going to give you about another 5 minutes, and we're going to turn it over to Mr. Bittner, okay?
Yep, that's good.
Well, I'll yield some of my time. I want to get into any issue.
Thank you, Mr. Bittner. Please continue, Mr. Taylor.
Let's see here. So, yeah, so looking at exhibit 26, I'm just going to show that exhibit 26 shows that the
Same
staff...
objection, just do that.
And we're going to admit it and have it go to wait.
So the exhibit shows that staff referred to neighbors as blatantly malicious and inhumane and careless and destructive in response to the placement of surveyed boundary markers of their property line. Now, in the same discussion, staff responded positively to suggestions of organizing a bike rally. So what I would like to do is I would like to call one more witness, please.
You've got 5 more minutes, Mr. Taylor.
Okay.
And I assume your testimony is over at this time?
Yes, that's fine. I would like to call Mr. David.
I don't have any questions.
Thank you, Mr. Bittner. So you've been sworn in already. This is the zoning expert.
Yes, this is correct.
He's already testified, been subject to cross-examinations. I don't believe it's.
I'm calling him as my
recalled,
witness.
and I'm just noting that for
I
the
don't,
record.
well, hold on. Mr. Taylor, what is he testifying to that he hasn't had an opportunity to testify to before?
There is a recent development with regards to the tavern's septic.
Is it a recent development in the 24 to 25 year?
It is a violation.
Is it a
Yes.
recent development in the
Yes.
24
Yes.
to 25 calendar year? Was the violation issued before April 30th of 25?
It was issued, wait, I'm sorry, repeat the question?
Was the violation in question issued before April 30th of 2025?
No, it was not.
Then
However,
we're not going to
it's-
hear testimony as regards to it. You can hear it at the next protest, we can hear it next year, but it's not relevant for this year.
And most respectfully, just so the record's clear, it's not a violation. It's a notice of possible pending corrective action. So
I have seen the letter in question. It is not from the time period in question. We're
Thank
not
you.
going to hear testimony with regards to a letter that isn't for the relevant time period. It can be addressed for whatever it is at a different date.
Mr. Hurdle, I would add, it may relate to a violation that, and obviously he hasn't testified yet, that did not literally come about the day the letter was issued. It may have.
It isn't a violation until it becomes a violation from the appropriate agency. The letter that I've seen is not a violation of any nature because there hasn't been an appeal period that has run in any capacity. Not to mention that, again, it comes from a different time period than the May 1st through April 30th of 25 time period.
Yeah, the only concern here, Mr. Hurdle, is that this is a factor with regards to public safety. And the actual violation that the health department was identifying is that this has been.
Mr. Taylor,
in
the
effect since
violation has been addressed by the
1992.
agency in question and is being handled in whatever the ordinary course is by said agency, and I presume the licensee, and it is not for the relevant time period that this protest is appropriate for. This was your witness that you had the 5 minutes for. This was your last witness. Mr. Bittner, it is your case.
Thank you very much. Thank you. So first off, if I may, I just want to move in. We previously filed 38 pages, some 225 signatures, petitions in support of the reissuance of the license to the Magothy Inn, attesting to the need of the license to accommodate the public, that the license establishing has been part of the neighborhood, as your records bear out, since 1947. Sign orders to the petition indicate that they're patrons, that the establishment doesn't unduly affect the health, safety, welfare of the surrounding community. So I'll move those in most respectfully.
Mr. Bittner, have you given Mr. Taylor a chance to take a look at those documents?
Sorry?
Have you given Mr. Taylor a chance
They
to
were
look
all
at those
filed
documents?
electronically with a copy to him.
Mr. Taylor, did you have any
back in-
objections
This
to
is the
those?
petition?
Yes,
No, I do not have any objections to the petition.
They're admitted.
filed back on January the 6th.
Thank you, Mr. Bittner.
Thank you. Next, I'd ask the board to take administrative notice of your records regarding this establishment. First off, as you well know, this is a violation-free establishment, family-run establishment. There have been no violations in the period in question, May the 1st of 2024 to April 30th.
So noted, Mr.
Thank you.
Bittner.
We have, and if I may, just by way of proffer, we have a large number of community members, patrons of the Magothy Inn in attendance. They've signed in. If I could ask them just to rise and just identify themselves for the record, and I proffer that they're here to tell you that they believe this is a well-run establishment, that it's an establishment that the community values, that the owner donates his time and space to community endeavors, and that they are here to ask that the license be renewed in its current form. And sir, if we just start with you in the far right, first row, just state your name, please. Perhaps if we could ask anybody to sit and then maybe stand one at a time, or however you.
Yeah, we need to swear them in if they're going to
Okay,
testify. If we're going to take
okay.
them as a head count, we can do that.
Thank you. I believe the clerk wants to swear everybody in.
So everyone, please raise your right hand that we'll be testifying for or against. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You can please be seated. As you stand up to testify, can you please clearly state your name and address for the record? You did state it during your testimony, sir. Thank you. Ma'am.
Bonnie Street, 446 Riverside Drive. I walk the neighborhood absolutely every day. I walk by the bar all the time. I never see them at all. I go in. I worked for AARP for 25 years. One of the biggest issues for seniors is isolation. I go in there during the day and guess who's in there? All 65 and older. It's a good part of what this neighborhood bar is. I would have a lot more to say, but I think
Mr. Bittner, are we going to have everyone testify? Because I don't think we're going to put on 20 witnesses for this, because then they'll be subject to 20.
If the board's happy to accept.
We're happy to take notice that they're all in support and that they all believe it's a good community establishment. I think that's what seems to be what you're proffering, correct?
Yes.
And what was the head count, just to be clear?
I counted 18 today.
18. We'll take note that there are 18 people in support. And we do appreciate everyone being here. My apologies. It's just a time-sensitive issue. Mr.
She
Bittner?
came 3 times already, so if she could please, that would be very nice.
If the chairman, please.
Please.
Hi, my name's Kim Stankiewicz. I live on the corner, 305 Beach Avenue. Moved in 8.5 years ago, knowing that bar was there. We are at an end of a neighborhood that is full of motorcycles, dirt bikes, what do you call it? Golf carts. Oh my God, the golf carts. They're all loud. They all have music playing. We're used to it. We know. I mean, there's no problem. I sleep very well at night. And I am literally on the corner, see the traffic coming and going every day, every night. And yes, I go there as well every other Friday night.
I would, Mr. Chairman, members of the board, I would proffer that we do have the manager here, Ms. Thompson, been here previously. She would reiterate that they run a tight ship, that when they're made aware of issues, as you see in Exhibit 8 and 9 introduced, they try to respond to it. Is that right, ma'am?
Yes.
Thank you. I would proffer Mr. Panache is here.
Can we do one more, please?
Whoops, before we get to that, ma'am, step up.
She was here
A
last time.
lot of, most respectfully, I thank you for the indulgence. A lot of neighbors have been here several times and have important things to say. Ma'am, your name?
Melanie Heyer. I've worked at the magazine for 10 years. Yes. I've worked at the magazine for 10 years.
Can you also state your address for the record,
Yes,
please?
818 207th Street, Pasadena, Maryland, 21122. I've worked at the magazine for 10 years. That was my livelihood. I never wanted to leave. I'm a disabled veteran, and I found my place, and I wanted to work there until I couldn't work anymore. No problems there. Never seen an altercation. I had to leave and change my job because it was threatened every day by this woman behind me. I had the other woman, Regina. I had to walk my elderly patients outside during the day because her pit bulls are running loose, running amok on our driveway where we park. Elderly patients that I would help down the steps, and they would fall. They would be so upset. And I don't think that's right that that kind of stuff has not been mentioned. Or when we opened for COVID and we were closing at 10 a.m., and she would come over, Catherine would come over, open the doors and yell when the jukebox wasn't even on when we were leaving by 10 o'clock. It just doesn't seem fair. It's an injustice to our community. I don't think it's right that things aren't being brought up that should be addressed. And it just seems like it's a lot on one person. He's a great man. He's a veteran. His father was a great man. And I have so much I could say, but I'm upset. This is very emotional for me and everyone else. 10 years. 10 years I've worked there. And I had to walk away because my job was constantly threatened. And I don't think it's right.
Mr. Hurdle, do I get to cross-examine any of these witnesses? Because they're just getting to come up and make testimony. I mean,
If you'd like to
Well, you
question
keep
the witness.
repeating yourself.
I'm sorry, how am I repeating myself?
I'm done. Thank you. Thank you.
Ma'am,
I'm sorry.
Ma'am,
Yes, sir. Yes, sir.
Mr. Taylor, you're welcome to cross-examine.
So you had said that you were threatened every day by Catherine, correct?
Taking my job, that's threatening. That's my
Okay, how
livelihood,
did-
sir.
Okay, please identify how she threatened your job every day.
Coming to these hearings, having to leave work early, having to go get babysitters, wondering if I have a job to come to the next day because we aren't getting our liquor license. That's a threat to my livelihood.
Okay, but it's not a threat every day.
It's a
That's
threat
all.
every day when you wonder if you have a job to walk into. Yes, it is, sir. Look it up. Look it up. I need to know if I have a job to go to every day. Yes, it's important. Thank you.
Have you ever tried to have a conversation with?
I don't want to. Coming to these hearings and seeing how you guys act and bully, I don't want to talk to you. If I want to talk to you, I'll do it right here. I'm not addressing you anywhere else on social media, mail, nothing.
Ma'am?
What I have to say is right here.
Well, what is it that you said to Catherine in this hearing in the
I
previous?
just said what I said.
Well, I'm sorry,
On the
could you repeat
panel,
it for
to the
me?
panel, that I left my job of 10 years because of our bar
No, what-
constantly getting threatened to be shut down.
No, I'm
Not knowing, uncertainty. I don't work with uncertainty, sir.
Well, can you repeat what it was that you said to Catherine directly, please?
Ma'am, you got to, it's a civil matter.
Yes.
Please.
I feel like, I mean, what else do I need to answer? I feel like explaining that if I didn't have a job, that's uncertainty.
Ma'am, I understand the situation is you chose to testify. Mr. Taylor has a right to cross-examine
Fine.
you.
Yes,
Those
sir.
questions have to be related to the things you testified to, Mr. Taylor.
Well, we might as well get me a seat. May I have a seat?
Absolutely.
So at the end of the previous hearing session, you said something to Catherine.
Mr. Taylor, this isn't something that she testified to, so it would be outside the scope of her direct testimony.
Okay. Well, then I have no further questions for her.
Thank you, ma'am. You're
Thank
free-
you.
Thank you. Mr. Bittner.
Thank you, Mr. Hurdle. Mr. Chairman, members of the board, I believe that last I just make a proffer of Mr. Panache, just making that bit in the family. He's there until recently. He actually lived
Can I
in the
object
site.
before you get too deep? Will the board allow the parties to cross-examine Mr. Page if Mr. Bittner will be proffering his testimony? That seems a bit unfair.
I think that if it's going to be proffered, there would be no cross-examination. I think you'd have to have him answer these questions directly, Mr. Bittner, and he would be subject to cross, or you can rest. These are the two options.
So we rest.
So there's no testimony from the licensee, just to be clear.
Move in the application previously made.
Thank you. Excuse me. The board will issue a written decision as to whether the license is renewed. We anticipate it probably in the next 2 weeks.
Will
Sorry, Mr. Hurdle, I didn't hear what you said.
the parties be afforded any sort of closing statement?
If you'd like to have 5 minutes each, that'd be fine. And Mr. Fulton, I'll give you 5 minutes. Mr. Taylor, I'll give you 5 minutes. And Mr. Bittner, I'll give you 5 minutes.
Yeah.
He's my attorney. Am I not allowed to speak to my attorney? I'm not allowed to speak to my attorney? I just want to understand the rules. Am I allowed to speak to my attorney briefly?
Mr. Chairman, please continue. Was there anything more?
To be able to give us a closing
It will for
statement.
me. Absolutely. Thank you.
Mr. Bittner?
Yes, Mr. Chairman.
Mr. Taylor?
Yes.
Thank you.
Thank you, Mr. Chairman. I will be brief.
Sure.
I have no doubt that this is a cherished tavern in Pasadena, Maryland. The fact remains, however, that the testimony and the facts provided to this board by the two neighbors on the immediate adjacent sides of this tavern suggests that it operates in total disregard for zoning and a variety of other criteria that this board ought to consider when determining whether or not it is worthy of a renewed license. Now, under the AB Article Section 1405B, a license can't be issued for a premises unless the premises conforms with all zoning laws, regulations, and ordinances passed under our state's land use article. And in keeping with that state law, this board has rules and regulations which mandate very similar requirements. Under Rule 213, entitled Zoning, it states no license shall be issued which will result in the use of a premise which violates any zoning or other land use restriction. And separately, but similarly, without reference to zoning specifically, Rule 418 governs alterations, and it says very clearly, no licensee shall make any installation or alteration of a licensed premises or change the manner in which alcoholic beverages are dispensed without the prior approval of the board or until a permit therefore has been obtained from the Bureau of Building of Anne Arundel County and until the approval of the fire department and the health department of Anne Arundel County has been secured where said approval is required. Now, the testimony of the land use, zoning, and entitlements expert, David Phipps, was fairly straightforward. The Magathinian never got special exception to construct its carport. It never got permits to construct its carport. It certainly was never inspected. And similarly, they never got permits to construct the wooden deck that's currently in the rear of the tavern, which also was never inspected. Now, as for the special exceptions the tavern did obtain, It simply doesn't seem to follow the Board of Appeals conditions. The tavern regularly posts beer and liquor advertisements on the facade of their building, and in total ignorance of the county's Board of Appeals, the tavern did and has done virtually nothing to shield its immediate neighbors from ongoing and essentially new outdoor service of alcoholic beverages. Instead, on that area of the property contemplated by this shield, so to speak, they paved it and turned it into 2 parking spots. This board has wide discretion to renew this license, and I understand the board's argument that you are not the Office of Planning and Zoning or the Bureau of Buildings. I get that. But in one sense, I don't think it takes an ongoing zoning infraction case or an injunction case or a citation or a lawsuit to see that there are very obvious zoning violations going on here. If a tavern must have 50 parking spaces, but they only provide 30, it doesn't take a lawsuit to see they are not in compliance with the zoning code. Now, you've heard from the testimony of David Phipps that establishments like this require all sorts of trade inspections and permits and approval for a variety of health and safety reasons. They didn't get any of that for 2 of the main areas that they serve alcoholic beverages. Now, that in and of itself, one might say, so what? But the fact of the matter is they have constructed parts of this tavern on the licensed premises where all these violations that you've heard from Mr. Taylor and their neighbor take place. All the noise comes from the deck that has no permits. All the noise comes from the carport area that has no permits and is not otherwise approved by any zoning approval. The Board of Appeals never granted the Magathy Inn approval to construct that carport, much less for the service of alcoholic beverages. Now, again, at first glance, I get it. If there is no case, it's difficult for this board to sit here and say it's our job to do that. But cutting through that for a moment, it's clear as clear can be that there are zoning violations that allow for many of the behaviors and activities, if you will, which the testimony from Mr. and Ms. Taylor and their neighbor have offered to you this evening. Now, I think Ms. Taylor was here last time we met, and she said, I'm not trying to make this tavern go away forever. She just wants this tavern to comply with the same sorts of rules and regulations that every other licensed establishment in Anne Arundel County must adhere to. And in our opinion, in our stance, we put on a pretty substantive case that a ton of violations are getting, the tavern is getting away with a variety of violations that I don't think this board would allow other establishments to get away from. And I don't frankly understand why. The last point I will leave you with is that this is a non-conforming use. We all recognize the tavern is there and has been there for the required amount of time, but that does not save the fact that it is in fact a tavern in a residential community. If anything, it should receive increased scrutiny that these sorts of activities, behaviors, and requirements are met and avoided by virtue of the fact that it is quite literally sitting in a highly, highly residential area. Thank you.
Thank you. Mr. Taylor?
Sure. So under section 4210, the board must weigh specific factors before renewing a license. The ones that are most relevant to this case are subsection A4, uniqueness of services. The Magathy Inn, it offers beer, alcohol, snacks, a jukebox, and TVs. And it hosts events like birthday parties. I mean, these are common, ordinary services, widely available at most other licensed locations. The statutory standard for uniqueness requires something that is truly distinct and special. These ordinary offerings and events, they do not meet that standard. Under subsection A5, health, safety, and welfare, multiple videos that have been submitted as exhibits or part of the administrative record, they show that patrons urinating in the parking lot directly in front of the tavern without any staff intervention, even when roughly just 20 feet outside the tavern's front door. Now, neighbors testified to reoccurring late night noise and other disturbances in the parking lot, demonstrating a broader failure to monitor or manage the premises and patrons. Now, these activities violate Board Rule 4.20. Neighbors also testified that obscene language and racial slurs routinely carry from the tavern's outdoor service area into nearby backyards, including yards, that was in Catherine's testimony. I wasn't sure if you were looking at eyebrows, including yards where families with young children live. This directly violates Board Rule 4.16, which prohibits allowing any activity that undermines public peace, safety, welfare, quiet, or morals. Neighbors also testified to a pattern of confrontational conduct resulting from the tavern, including the licensee's involvement in terms of, let's see, patrons confronting neighbors, the Magathans Facebook page portraying neighbors as adversaries and blaming them for enforcement consequences, the licensee filing peace orders against neighbors to deter complaints, and the licensee installing surveillance cameras aimed at nearby homes, actions viewed by neighbors as intimidating rather than conciliatory. Taken together, this evidence demonstrates ongoing conditions disturbing neighborhood peace and safety, with a licensee not mitigating harm, but escalating it. Now, turning to subsection B1, the board may not or may deny renewal where the evidence shows B1(2) that the applicant is not a fit person to receive the license. So Board Rule 3.01 requires that all approved managers also be fit person. Now, the record shows that the licensee has failed to monitor or intervene in late-night disturbances, initiated confrontations with neighbors, and refuses to disclose issues with neighbors. The licensee has also publicly framed residents as the problem rather than taking responsibility, and attempted to silence complaints rather than addressing them. Now, fitness requires compliance with the law and good faith engagement with the community. So this record shows just the opposite. B1(3), that the applicant has made a material false, I'm going to skip that one for this. So in B1(5), if the license is issued, the operation authorized by the license would unduly disturb the peace of the residents of the neighborhood of the location described in the application. Now, without change, renewal would unduly disturb neighborhood peace for the reasons that I provided for subsection A5. The consistent thread in this record is a lack of control over patrons, over noise, over confrontation, and over compliance of obligations. This record supports that the licensee is unwilling or unable to control the tavern and operate during quiet hours. Protestants respectfully request that the board not permit this licensee to continue operating while in violation of conformance laws and regulations, operate during the quiet hours, or continue to violate Board Rule 4.16 and Board Rule 4.20.
Thank you, Mr. Taylor. Mr. Bittner?
Yes, Mr. Chairman, members of the board, thank you very much, and most respectfully, the protestants are wrong as to the law, and they're wrong as to their characterizations of the facts. The record is complete that in the time period in question, there have been no violations of any type. The protestants' own expert, Mr. Phipps, testified that there are no active violations pending against the license, that there are no stop work orders, that the license is active. You're correct that you are not the adjudicators of zoning and other type of collateral or sister licenses, health departments. And when a licensee comes in for a renewal and has those collateral licenses already in existence and valid, the question becomes the 4.210 factors for the time period in question. And the 4.210 factors clearly demonstrate, first off, this licensee's willingness and his staff's willingness to attempt to address the issues of the community. And you know that that's correct because the community is here supporting the licensee. 10 persons in the community purportedly signed the petition objecting to the renewal of this license. 2 households who have a long animosity for whatever reason have appeared here tonight. They've whined on about things that have happened decades and lifetimes ago. If there are issues to address vis-a-vis zoning, parking, persons who are driving on the street some distance away, there's proper agencies and proper mechanisms to address this. This establishment is unique in the neighborhood. It's a throwback to a slower, gentler time. You see who goes in there, who patronizes the establishment, and you see who doesn't. There's no basis to change anything to the Magathy Inn, and we'd ask you to approve the license in its current form.
Thank you. I appreciate everyone coming to testify. Mr. Taylor, Ms. Taylor, Mr. Phipps, all of the people on behalf of the licensee, everyone, all the protestants. Thank you so much.
We'll be in touch. Thank you. Good night. Thank you. Yep. Ladies and gentlemen, we're going to start in 1 minute. Please have a seat. You ready, Mr. Abe?
I'm ready.
Commissioner Song, you good? Bernie, you're good?
I'm good.
Uh-oh, what are you doing?
I got my caramels and good.
I may take one for later. Now that I got my sweets out of the way. Oh, yeah. Good evening, everybody. The March 10th, 2026 hearing for the Anne Arundel County Board of License Commissioners, AKA Liquor Board, is now in session. I'm going to start by making a motion, move to approve the transcripts from the January 13th, 2026 board hearing as the official minutes. All board hearing transcripts are now being stored electronically and serve as the official minutes. They can be reviewed online or by appointment with the board's office. I'm looking for a second.
I second the motion to approve.
Thank you, Commissioner. I have a second. All in favor?
Aye.
Aye. So carried. Mr. Hurdle, if you would, please.
Thank you, Mr. Chairman. I'm Abraham Hurdle, counsel to the board. At the beginning of every meeting, council makes a few brief announcements. First, the commissioners are part-time public servants and they have other outside interests. When they know they have a conflict of interest or the appearance of a conflict of interest, they recuse themselves. They cannot possibly know who will appear from the public in any given matter which may present a conflict of interest to them. If anybody believes that any commissioner has a conflict of interest in any matter, you have to announce that to us as the case is called, and that commissioner or commissioners, as the case may be, will deal with that accordingly. If not, then the commissioners will proceed with all hearings under the assumption that there is no conflict of interest. Secondly, the rules of the board provide that the chair, for the purposes of administrative and judicial economy, can have the board's counsel rule on the admissibility of evidence or objections if there are counsel present and objections are made. The board handles many cases at every hearing, and this assignment allows us to expedite the hearings. So rather than the chairman turning to me and me advising the chairman, I'll simply make a ruling, and my ruling will be that of the chair. Finally, renewals are here. As has been customary, the policy of the board and its administration, we're unable to process and issue new licenses and transfers between March 1st and the beginning of May.
Thank you, Mr. Hurdle. Chief, would you call the first case?
Thank you, Mr. Chairman. I have a few quick announcements. Just a reminder for everyone to silence your cell phones at this time if you have not done so already. And that Camp Mead Liquors and Starting Gate Liquors have both been postponed and removed from tonight's docket. That being said, our first case is for Turtle Returns I LLC, trading as The Green Turtle. Michael Wells, member authorized person. Jennifer Marshall, manager. Chelsea Francis Coleman, employee. Detective Middleton, 1061. Corporal Ford, 2286. Inspector Jason McCarthy. This is a Class BLX Deluxe Restaurant, BWL, with entertainment with outside service, outdoor service, located at 1407.
Do you waive
South
reading,
Main
Mr.
Chapel
Mister?
Way. I waive the reading. Thank you, sir. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand, please. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated. Starting from my left, can you please state your name and address for the record?
Detective Middleton, Anne Arundel County Police District Operations Unit.
Kevin Ford, Anne Arundel County Police Special Operations.
Michael Wells, 304 Songwood Court, Millersville, Maryland, 21108.
Jennifer Marshall, 1417 Duncan Street, apartment 408 in Odenton.
Thank you. Is Ms. Coleman present?
No. For the record, Mr. Chairman, members of the board, David F. Mr. Winter and Bartlett LLC, representing the respondents today. I sent the board a letter, and I think we were here last, we advised the board of this, but Ms. Coleman was terminated immediately after this violation was brought to our attention. We've had no further contact with her. We've had no way to produce her here this evening. We do, though, have the manager who the board has also summoned today, Ms. Marshall, with us, as well as the licensee, Mr. Wells. And also, I would say that we're not contesting the fact that this sale was made to an underage person.
Okay, thank you, Mr. Mister. I am curious, why did we wait until today to get this letter to us?
Honestly, Mr. Chairman, that's my fault. I thought we had already sent it, and when I queried my paralegal this morning, she told me, no, it hadn't been sent. We'd only sent an entry of appearance. So that's all on me. I thought it was done. I know that I told the board when we were last here that she had been terminated, and we didn't think we could produce her.
No, and that's fine, especially under the circumstances, but thank you for sending it, and it will be part of the official record. All right. Detective, you want to go ahead and proceed?
Good evening, Chairman and Commissioners. Once again, Detective Middleton, Anne Arundel County Police. This incident was December 4th, 2025, approximately 4:25 in the evening. Corporal Ford and I were working Operation Save, conducting alcohol sales compliance checks of retail businesses and restaurants. The confidential source was searched before and after the detail to verify that she did not have any money or identification on her person. The confidential source's age was verified through Maryland MVA administration prior to the detail, and a certified copy of the driver's license was obtained. I do have that here tonight. We directed the confidential source, 20 years of age, to enter the Green Turtle Restaurant located at 1407 South Main Chapel Way in Gambrills, Anne Arundel County, Maryland. We observed the confidential source enter the restaurant, sit at the bar. The CS ordered a Angry Orchard hard cider from the restaurant bartender. The bartender did not ask the CS for identification and served the confidential source the Angry Orchard hard cider. We entered the restaurant and the CS exited. We know through our training, knowledge, experience that Angry Orchard hard cider is an alcoholic beverage. We identified ourselves as police officers, identified the bartender as Miss Chelsea Coleman via her Maryland driver's license. Ms. Coleman advised that she has had the alcohol awareness training and has been working there for 1.5 years. Photograph was taken of Ms. Coleman and her identification. Photograph was taken of the Angry Orchard hard cider, and also the Anne Arundel County liquor license was properly laid on the wall. The manager was located, identified as Miss Jennifer Marshall, who's here tonight to my left. She was very cooperative. The bar was very busy, and a copy of the report was forwarded to Anne Arundel County Liquor Board, and that would be our statement of facts.
Mr. Mishra, have any questions?
No cross-examination.
Chairman, any questions?
No questions.
Commissioners, any questions? Turn over to you, Mr. Mister.
Thank you. If I may proffer initially and then query the licensee. Mr. Chairman, members of the board, this premises, this restaurant was opened in January of 2022. There are no prior violations before this board. As we've already stated a couple of times, immediately as soon as we were informed of this violation, the bartender was terminated, and that is the policy of the Green Turtle Franchising Corporation. They do it even with a more experienced employee like this. And it's not the easiest time in the world to get new employees these days. But that's what they think is necessary to take proper disciplinary action and also to be an example to other employees as to what the outcome would be if they don't follow the law. Ms. Marshall was the manager there that evening. Even though she had not as yet been registered with the board, I would point out that she is at this time, as well as 2 other Anne Arundel County residents, in addition, of course, to Mr. Wells. She was, though, alcohol awareness certified at the time. The current policy and practice of the Green Turtle is that all employees, all servers, that is, within the first 30 days of their employment, are trained in an alcohol awareness program. They use the TIPS program. They do that in-house because they train so many people at once. And they have a seminar monthly because they do have some frequent turnover employees. The managers on every shift remind the servers at pre-shift meetings of their obligations to make sure they card and determine the appropriate age for patrons, and also that they don't serve anyone who appears to be visibly under the influence of alcohol. They have the before date posted every day. In other words, anybody who is born after this date is not eligible to be served alcohol, just as a graphic reminder to the servers. The policy is that everybody gets carded. And I've specifically queried Mr. Wells about that. I said, even an old guy like me, and he says, yes, they would card me. My experience is when I've gone there, I have been carded, believe it or not. And the Green Turtle Franchising Corporation has 3 licenses currently in Anne Arundel County. They have many other licenses throughout the state of Maryland and the Mid-Atlantic region. They are generally good corporate citizens, and obey and have a good, very good structure. I wish I could say that all of my clients had such a structured thing, and approach and policy. Unfortunately, this happens. People make errors. People are human. Miss Coleman was certainly human here, and she paid a price economically for this. Mr. Wells, the things I proffer to the board, are they true and accurate?
Yes, sir.
And approximately how many other licenses do you have within the state of Maryland?
I have 4 in Anne Arundel County.
Okay. And your policy, in fact, is universal, not just for this instance, that if your servers serve someone underage, they are terminated. Is that correct?
Yeah.
Regardless of the longevity of their employment?
Yep, all company employees are subject to the same policy.
I'd like the board to query Mr. Wells.
Mr. Wells, I'm going to address this question directly to you. I believe this is your first violation at this
Correct.
location for serving a minor?
Correct.
Well, and I understand you've had this license since 2022. Am I correct in that?
Yes.
Well, that's nice to hear that you've been in business for 3 or more years, and this is your first violation. It's a little refreshing. Unfortunately, it is a violation that we take very serious. The question I have really pertains to your managers. I noticed on your manager's agreement that I hold, which is dated February 17th, 2026, you had 5 people in there. 2 of them, Tamara Holmes and Miss Campbell or Mr. Campbell, are no longer there, or are they still there?
They're still with the company. They're no longer at the restaurant.
Okay, because their manager's agreements, on alcohol awareness rather, has expired.
Yeah,
So-
they left at the end of, Tamara left before November, and Dewan left at the end of the year.
Okay, fine. And Young, Cheney, and Marshall was still employed there?
No, Miriam, who was the general manager at the time of this incident, was terminated. And who was the other one?
Christopher Cheney and Jennifer Marshall.
Yeah, Jen is still employed there, and so is Chris.
Okay. You might want to get with Michelle in our office and get this management agreement updated. And she'll handle everything and walk you through it. So, but you do want to definitely do that.
Yeah,
it
we
is a-
exchanged a couple emails this week, so I think we should be in a good place now.
Oh, good, good. I have no further questions.
Commissioners, any questions?
No questions.
Okay, Mr. Wells, Mr. I'm going to make a motion, and it's pretty standard as far as the violations, the way this board tries to handle it. And that is, we have, if it's your first offense, and if you're found guilty, which I'm going to make a motion that we do because you're not contesting that, that we fine you $500 for sale to minors, another $500 for selling to someone under the 21 years of age, which is the state law. On the alcohol awareness, because there was a violation there, $250, and the ownership and cooperation, and that falls back on management of those employees that night, not necessarily you, but your staff. $250, and because of the cooperation, which was the fact that we had to postpone from last hearing, $100. So it's $500 on the 2 underage 21s and minors, $250 on alcohol awareness, ownership, and operation, and $100. That's $2,600 total in fines. No suspensions or anything of that nature, but please be careful, because every time you come in within a 5-year period, and that clock kind of starts now for you, usually the penalties are much more severe each time. So please be careful. Thank you very much. I'm looking for, I'm sorry. It was 500, yeah, 500, 506, 1,600. I apologize. So that's a motion. I'm looking for a second.
I second.
I have a second. All in favor?
Aye.
Aye. So be it. Thank you.
Chairman,
and
may
Have
I
a good night.
inquire when the fine is due by?
Mr.
Okay, great, thank you, Mr. Harrison.
Okay, thank you. Have a good evening.
All right, our next case is for AM Hospitality Services LLC, trading as Home 2 Suites, Arundel Mills. Angela Sarif, member authorized person. Elia Yasmin Cooper, employee. Alexis William Eros, front desk manager. Donna Vivica, employee. Detective Middleton, 1061. Detective Maracas, 2318. Inspector Frank Faulkner. This is a Class LSH Limited Service Hotel BW Sunday license located at 7545 Teak Road, Hanover, Maryland, 21076 with no restrictions. There's 4 violations. So the first one's for rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.01A, titled Minors. Reference to Anne Arundel County Police Report Number 26-702003 by Detective Middleton, Detective Maracas. Incident dated January 19th, 2026. Second violations for Maryland Annotated Code, Alcoholic Beverages and Cannabis. Title 6, Section 6-304, selling or providing alcoholic beverages to individuals under the age of 21 years. In reference to Anne Arundel County Police Report Number 26-702003 by Detective Middleton, Detective Maracas, dated January 19, 2026. Third violation for alcoholic beverages and cannabis, Title 11, Section 1902, titled Alcohol Awareness Program. Reference to Anne Arundel County Police Report Number 26-702003 by Detective Middleton and Detective Maracas. Incident dated January 19, 2026. And the last violation is for rules and regulations of the Board of Anne Arundel County, Chapter 4, Section 301D, ownership and operation, reference to the same Anne Arundel County Police Report Number 26-702003 by Detective Middleton and Detective Maracas. Same incident date of January 19, 2026. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Please be seated. Starting from my left, can you please state your name and address for the record?
Detective Tom Middleton, Anne Arundel County Police District Operations Unit.
Detective Maracas, District Operation, Western District.
Donna Marie Stidham, General Manager, Mandela Saraf with the liquor AM Hospitality, one of the licensees. Alea Cooper, front desk agent at 7545 Teague Road, Hanover, Maryland.
William Arias, Assistant General Manager, Home 2 Suite, 7545 Teague Road, Hanover, Maryland.
Thank you. Is Ms. Saraf here? Oh, you're okay. Thank you. Ms. Ertl?
Detective?
Good evening, Detective Middleton. This incident was January 19th of 2026. It was approximately 12:25 in the afternoon. Detective Maracas and I were working Operation Save, conducting alcohol sales compliance checks of retail businesses and restaurants. Confidential source was searched before and after the detail to verify that he did not have any money or identification on his person. The confidential source's age was verified through Maryland MVA administration prior to the detail, and I do have a certified copy here tonight. We directed the confidential source, 19 years of age, to enter the Home 2 Suites located at 7545 Teague Road in Hanover, Anne Arundel County, Maryland. We observed the confidential source enter the establishment. Confidential source grabbed a Michelob Ultra beer from the cooler next to the front desk. The CS walked over to the front desk clerk, and the clerk asked this confidential source, cash, credit, or charge to your room. The front desk clerk did not ask the CS for identification, and then sold the confidential source the Michelob Ultra beer and subsequently handed him a bottle opener. We entered the hotel, identified ourselves as police officers, identified the clerk as Miss Elia Cooper from our Maryland driver's license. Ms. Cooper advised that she has had the alcohol awareness training. Photograph was taken of Ms. Cooper and her identification, and also the Michelob Ultra beer, and the Anne Arundel County liquor license, which was properly displayed on the wall. The general manager was identified as Ms. Donna Vivica, and she advised that she was on the manager's agreement. She was cooperative. The front desk manager was identified as Alexis Arios. He advised that he was on the manager's agreement for the liquor board. The hotel was not busy. The copy of the report was forwarded to the Anne Arundel County Liquor Board, and that would be our statement of facts.
Licensees have any questions? Mr. Chairman, any questions?
No questions.
Commissioners, any questions? Turn it over to licensees.
Yes, good evening, Mr. Chairman, members of the board. I'd like to say that once this happened, I took this very seriously. I put my entire team, not just the party, back through TIPS training for a refresher training that was approved by Anne Arundel County. We did that in person the following week after. We also ordered an ID scanner so that we can also check IDs more easily, and not only for age, but for the validity of the IDs that are being presented. Again, have taken this very seriously. We understand that this violation is an offense that we will have to have a citation for. But we want you to know that this has never happened at our property. We've been open since 2016. I've been general manager there for the last 5 years, and I can assure you it will never happen again.
Thank you.
Any questions, Mr. Chairman?
I have no questions at all. Thank you.
Commissioners, any questions?
No questions from me.
Good. Okay, is there anything else you want to say before we make our motions?
No, sir, just that we took this very seriously. We've had daily huddles and meeting with our teams, and we understand exactly where we went wrong. And again, it won't happen again at our location.
Okay, well, that's truly and much appreciated. The fact that you retrained your staff, the entire staff. Yes.
I'm sorry, what's your name? The person speaking, I'm sorry, ma'am. What's your name?
Oh, me here?
Yes, ma'am.
I'm Donna Marie Stidham. I think they have my name wrong on
What do they have it as?
I think they spelled it D-O-N-A. I'm not sure.
Donna Vivica?
Yes, I'm Donna Marie.
Thank you.
Well, we'll get that straightened out. All right.
Yes.
Okay, getting back to what I was saying, I do appreciate the fact that you do take it serious. I wish everybody took it as serious. Unfortunately, it is a fairly serious offense. I also appreciate the fact that you're getting a scanner, but I, for a fact, in 20 years in this business, know that especially at hotels, the alcohol sometimes slips right out of that cooler and right out the door before you even know it. So the scanner might help for somebody that tries to, bring a false ID or try to pull the wool over your eyes, but it's not going to help you being vigilant at that
It is
desk.
secured at our location. The cabinets are secured now. They have locks on them.
That's where I was going with
Yes,
this.
sir.
So that's good to know. With all that being said, I'm going to go ahead and make a motion. It's first offense since 2016. For minors, $500. Under 21 years of age, $500. Alcohol awareness and the ownership and operation, each $250. That's a total of $1,500 total in fines. And like I just explained in the last case, if this motion passes, please be careful when you come back, because if you come back within a 5-year period, it's going to be much more severe. That's in the form of a motion. I'm looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye. So be it. Good evening, and thank you for your presentation. It was well done.
Thank you.
Thank you. Have a good evening.
Our next case is going to be for Katana Sushi of Hanover, Inc., trading as Tomo Asian Cuisine. Ong Chong, President. Jacqueline Lee, Yi Ting Gao, Employee. Detective Middleton, 1061. Corporal Ford, 2286. Inspector Frank Faulkner. It's Class H Restaurant, BWL, with entertainment Sunday service, located at 7698 Dorchester Boulevard, Suite 201, Hanover, Maryland, 21076.
Yes, waive the reading on the
Thank you.
violations.
Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand, please. Thank you. Do you solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please be seated. Start from my left, name and address for the record.
Detective Middleton, Anne Arundel County Police District Operations Unit.
Corporal Ford, Special Operations Division.
Michael Schur, attorney on behalf of Mr. Hong Chung, the licensee, who's currently out of the country due to a family illness. I do have his affidavit here. I could, in support of that.
Jacqueline Gow, address 12615 Marley Drive, Bowie, Maryland 20720.
Thank you. Mr. Erdl?
Just a moment, Chief Inspector.
Oh, do you want me to repeat it?
The affidavit's fine. I just think that our policy, counsel, our understanding is both individuals were summoned to the hearing today.
Correct. It's unfortunately, Mr. Chung's grandmother is seriously ill. He's been out of the country since middle of January, and he's still overseas. And he has retained my services, and this matter is not being contested by Mr. Chung.
Unfortunately, we require either have to waive their appearance via some sort of acknowledgement from you ahead of time, or we have to cite you for a lack of cooperation as another violation.
I apologize. I was not aware there has to be a waiver. I was under the assumption an affidavit from the licensee would be sufficient.
Just a moment.
No response? Okay.
Counsel, it sounds like we reached out to the licensee individually via email as well beyond the summons, and there was no response at all.
Unfortunately, he normally used Gmail. I believe that was the address he has. He does not get that in China. He has to use a separate email. I have to use a separate email to communicate with him. It's a qq.com email address. It's a completely different address.
We understand. I think the concern is that just our policy as it has been for all licensees and all counsel, and you're not the first. Let me be very clear. This is not the first time this has happened. But we're going to have to postpone the matter, and we'll have to issue a citation for lack of cooperation.
Excuse me for 1 second.
And counsel, who do you represent? Do you represent the clerk or the licensee?
The licensee,
Okay.
Mr. Chung.
Sir, we're going to have to, I think this is the second time that this has been in.
Yes, it is.
For this issue.
Counsel.
So we're certainly happy to, we have to postpone it again. It'll come back the next time we have a hearing.
Okay, if you could kindly advise what would be the procedure for me to appear on his app. There's a
You
good
can just send us a
possibility-
letter asking for his appearance to be waived.
Okay, I will do that then.
But I don't know that he can dispute much, given the fact that he is the licensee and he would be the only one.
Yes, unfortunately, I just prepared an affidavit for him. He's
I
not
understand.
disputing the violations.
Yeah, we're going to postpone the matter.
Yes, thank you.
Thank you,
Thank you,
sir.
Commissioners. Thank you, Counsel.
Our next case is going to be for Melody MAA LLC. trading as-
reading.
Thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. This is in reference to preserved wine and spirits. All right, please remain standing so I can swear you in. Raise your right hand, please. Thank you. You solemnly swear and affirm under the penalty of perjury. The testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Be seated. Starting from my left, name and address for the record, please.
Agent Joel Hawk, Maryland Alcohol, Tobacco, and Cannabis Commission.
And good evening, Mr. Chairman, Commissioners. My name is Brian Lyman, Lyman, on behalf of the
licensees, and the clerk.
Good evening, this is Tawal Patel, 9228 Homestead Court, Laurel, Maryland 20723.
Good evening, Tushar Patel, 424 Barberville Road, Laurel, Maryland.
Vipul Patel, 1519 Ketla Court, Hanover, Maryland, 21076.
Thank you. Mr. Hurdle?
Yes, sir. On Monday, December 8th, 2025, at approximately 10 a.m., I responded to Preserve Wine and Spirits located at 7698 Dorchester Boulevard in Hanover, Maryland, 21076, for the purpose of a routine inspection of the business. I spoke with the clerk, Vipul Patel, and identified myself as an agent with the Alcohol, Tobacco, and Cannabis Commission. I observed the trader's license 02307-877 on the wall and to be valid and properly licensed for the products they had for sale in the store. I then conducted a systematic inspection of the cigarettes and other tobacco products displayed in the store. The clerk produced invoices for the cigarettes, and on inspection, they all appeared to have valid Maryland tax stamps. The liquor license 868 Type A BWL was on the wall and valid under the license Tushar Patel and Devavel Patel. I conducted a systematic inspection of the alcohol on the premise and asked the clerk what, if any, allocated alcohol they had in the store. The clerk stated that they did not have any allocated alcohol delivered to the store. During the inspection, I located a bottle of George T. Stagg, 2 bottles of Buffalo Trace, 1 bottle of Pappy Van Winkle 15-year, and 1 bottle of Kentucky Owl confiscated under the front counter behind several stacks of mini bottles. I also located 1 bottle of Weller's Special Reserve and 3 bottles of Kentucky Owl Batch 11 and 12 on the shelf behind the counter. The clerk stated that he never saw the bottles found under the shelf and contacted Mr. Tushar Patel. Mr. Patel advised me on the phone, stated that the Pappy Van Winkle he purchased from for a friend in D.C. and was going to give it to him. He said the other bottles were from the previous owner and would attempt to locate the invoices. Mr. DeVille Patel arrived at the store and I advised him of my inspection. I seized the liquor under AB 6-311B1, purchasing, keeping an alcohol beverage on licensed premise which was purchased from other than a licensed wholesaler, AB 1-408, records violation, and TG 5302, did unlawfully possess, buy, transport, sell, store, or allow another person to buy, store, sell, or transport an alcoholic beverage upon the tax provided by the law had not been paid. Mr. Vittel was signed the confiscation receipt, and the seized liquor was submitted to the ATCC evidence room, and this report was forwarded to Arundel Liquor Board for a hearing. On note, they did provide invoices for the Kentucky Owl, so 4 of the bottles were returned.
Mr. Lyman, any questions?
Thank you, Mr. Hurdle. Yes, Agent Hawk, were the licensees and the clerk polite and respectful of your requests?
Yes, sir.
Okay. Were they generally cooperative?
Yes, sir.
Okay. About how long did your inspection take?
Roughly an hour, probably a little over an hour.
Okay. And did you have any reason to believe that the bottles located in the store were obtained from any other source than what you were explained by the licensees?
I'm sorry, can you ask that again?
Did you have any reason to believe that the bottles were obtained in any other manner than were described to you and as you related in your report?
No, his explanations, what he gave, there's no invoices, so I have to take him for what it's worth.
Okay. Do you know when this license was transferred to these licensees?
No, sir.
Okay. Thank you. I don't have any further questions.
Chairman, any questions?
Yes, I believe this transfer was about 1.5 years ago. Am I correct in that, Mr. Lyman?
I have October 2024 when the license was transferred.
Yeah, that's
what my
what I
clients
said.
related to me. Unlike some of them, I was not involved in that transfer. So.
Okay, thank you. Agent, besides the bottles that were returned, what was the final count on the bottles that were confiscated and not returned?
I don't have that with me, sir, but a rough estimate, you're probably talking about $8,000 worth of liquor. The Pappy Van Winkle's is a very rare bottle, and it was a 15-year, so.
Okay, thank you.
Yes, sir.
No further questions at this time?
Commissioners, any questions? Mr. Lyman?
Thank you, Mr. Arundel. My clients are going to enter an admission to the charges and offer an explanation, which I'd be happy to proffer to the board. Tushar Patel obtained 2 bottles, as he indicated to the agent, that he was going to gift to a friend who was traveling from overseas. And it was his mistake to have them on the licensed premises. He was unfamiliar with that requirement and is certainly familiar with it now. Those were the 2 most expensive bottles, the Pappy Van Winkle and the, I believe one was a Buffalo Trace.
Just
What is
The
it?
Wellers.
The Wellers.
Would be the next one.
Yeah.
Yeah. Say it in the microphone.
Pappy and Jot Stack.
Okay. Those are the 2 bottles that you obtained that you were going to gift to your friend?
Yes, sir.
Okay. He kept those on the establishment just for the weekend and had intended to give them over to the friend who was traveling from overseas. The other bottles, the Kentucky Owls, actually had been delivered, contrary to the clerk's knowledge. Mr. Patel did not realize that they actually had invoices for those, and so he did not produce the invoices on demand. As the agent testified, those invoices were produced at a later time, and those 4 bottles were returned by the commission. And if I'm doing my math right, there were 9 total bottles confiscated. I've talked about 4 bottles returned and 2 bottles. So that leaves 3 bottles that were on the premises that there were no receipts for. This license transferred to 2024, and the only explanation the licensees really have for the bottles that were on the premises were that they were on the premises when they obtained the transfer of the liquor license, and they were unable to locate any of the business records relating back to when those deliveries actually happened. Nevertheless, they acknowledge that they have an obligation to produce the records for the agent. They are not challenging the seizure and disposal of those alcoholic beverages. I merely mention that as sort of an anecdotal statement about where the bottles came from. 2 of the bottles were intentionally brought to the premises by a licensee. That is a clear violation, and he's making no claim to receive those bottles back. The 3 bottles that we don't have the records for were bottles that they presume must have been left on the establishment. They were not listed for sale. They were just sort of under the cabinet, as I understand it, and discovered by Agent Hawk. So, that's the explanation. I will mention to the board that I have duly interrogated my clients over this violation and asked them how many prior violations they've had. They've had 2 violations for underage service of alcohol. This, I explained to them, is substantively different, but nevertheless, it is another violation of the board's rules and regulations and the Maryland statutes, and that they should expect a fine commensurate with that many violations in the short time, relatively short time that they've held this license. We would ask the board to consider that they don't offer anything other than an explanation. There aren't excuses here. I've encouraged them to be absolutely familiar with the board's rules and regulations, as well as all the applicable statutes, and they understand how serious this is, and they don't intend to appear in front of the board again for any violations. They know what they need to do to fix this particular problem, and they would ask the board to enter appropriate deliberations and a fair penalty. Thank you.
Mr. Chairman, any questions?
No questions at this time.
Commissioners, any questions?
No questions.
Okay, Mr. Lyman, thank you for everything, and I understand the admission that the licensees are making in this case. And I understand that there's a possibility that those 3 bottles may have slipped through under the counter and not aware of, even though it is your responsibility to be aware of this. And I know you understand that, which is the biggest hurdle to get over, making sure you understand what the rules and regulations are that you have to abide by. It's a significant loss of your friend's alcohol, but unfortunately, it is what it is, you know. I'm going to go ahead and make a motion, excuse me, that we find you guilty in both cases. And that is the restriction on purchases and sales of retail dealers and the record keeping and reporting. I'm going to make a motion that we fine you $500 in both cases, a total of $1,000. And the alcohol is being held and will be dispersed or taken care of through alcohol, tobacco, and the cannabis. And that's pretty much what I do in a normal case with this. You do have those violations that Mr. Lyman talked about. So what I took in consideration is the fact that it's not your very first violation. So you do need to be careful, not just the sale to minors, but things like this. So the motion is two $500 fines on the two charges and the loss of the alcohol. Looking for a second.
I second.
I have a second. All in favor?
Aye.
Aye. So be it. Hopefully we won't see you back here. Thank you, Mr. Lyman.
Thank you, Commissioners. Thank you, Mr. Chairman.
Thank you.
Our next case is going to be for Liquor Outlet Glen Burnie LLC, trading as Liquor Outlet Glen Burnie. Kash Kumar Patel, member, Inspector Jeremy Fisher, no restrictions. This is for an amended application, continued from the February 10th, 2026 hearing. Currently, Vivek Patel, member, Sandy Patel, member, Kinjal Jossi, managing member, on behalf of Dorsey Square LLC, trading as BWI, Deli and Convenience Store located at 1272 Stony Run Road, Hanover, Maryland, 21076. This is a Class A packaged goods, BWL with Sunday license. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand, please. Yep. Few more seconds to let people come forward. All right. Yeah. All right. Please remain standing and raise your right hand so I can swear you in, please. All right. Do you solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay. You can please be seated. Starting from my left, actually, if you want to remain standing for a minute, starting from my left, name and address for the record.
Stephen Brown, PROWN, Doc and Annie's Liquor Store. My office is 706 Giddings Avenue, Annapolis, Maryland.
Liam Sullivan on behalf of Anne Arundel County Licensed Beverage Association.
Buzz Liquors, Amar Safi on behalf of Buzz Liquors, 7342 Ritchie Highway. Shwadi Liquor, Chesapeake Center Drive, Glen Burnie.
We'll go to, actually, in the back, sir. Yeah, can you, both of you come forward so we can hear you if you're going to be testifying?
John.
All right, so can you please restate your statement?
Yeah, my name is Keegan Sai.
Thanks, sir.
John Harrison, 707 Linden
Thank you, sir. Thank you. There's what, three that step?
Shirish Gilpara from Chesapeake Liquors in Glen Burnie, 6720 Ritchie Highway, Suite C, Glen Burnie, Maryland.
Thank you.
Satish Patel, 720 Church Street, Village Liquor. Thank you. Park, Maryland, 21225. Jay Patel, 6023 Ritchie Highway.
Thank you. And we'll come back to the table, sir.
My name is Kaushik Kumar Patel. I'm living at 720 Supreme Court, Cambridge, Maryland, 21054.
Thank you. You can all be seated now. Appreciate it. Ms. Turtle?
I have a preliminary matter. I'm just going to go ahead and I want to make a motion to the board. Basically, we were here in February 10th. The applicant for the transfer had fully put on their case. The board listened to all witnesses and called for any opposition testimony at that hearing. So I would motion that the evidentiary portion of this hearing should be closed. You know, everyone had an opportunity to appear at the February 10th hearing. Notice was properly posted, and for all intents and purposes, you know, it's the applicant's position that they've waived the right to appear and testify on, you know, in opposition of this license, if that's what they're here for. So, and make a motion to close the, you know, not allow any further evidentiary testimony before the board and focus solely on the amendment to the application, because that is what we were called back here for today.
And Ms. Wheatley, just to clarify, the amendment was to remove one of the previous applicants, is that correct?
Correct. It was
This gentleman was
solely-
before us last time?
Yes, Mr. Kaushik Patel and Brajesh Patel were here at the last hearing. Brajesh was removed as a licensee due to his, he has an interest in another Class A license in a separate county. So he is now, the only involvement he has is a manager of the license, which is, you know, permitted under the rules. He has no financial interest in the license as of currently with the amendment that we submitted to the board. So Mr. Kaushik Patel, who's here today as the applicant and licensee, is the sole member of the liquor outlet Glen Burnie LLC.
Thank you. Sir, did you want to be heard?
Yes, I would say, you know, the whole reason we're back here again is an opportunity to fix a problem that wouldn't have gotten them approved before. So the fact that they are taking advantage of a technicality to come back today to fix themselves shouldn't be availed to block the folks who are here to rightly challenge this addition to an oversaturated market at the end of the day. The board also, I mean, there's plenty of evidence that you guys have already heard in terms of the oversaturation of this market when it came to the sip and learn. So we're dealing with a pretty serious issue here.
Sip and Learn was a new license, is that correct?
Yeah, well, you have to evaluate the same concept whenever it's a transfer of a license that we're dealing with here. This case is exactly the type of case why you should be following those transfer requirements of the new license factors because of the fact that you went from a teeny tiny little place on the other side of the airport, dropped smack into a place.
He's putting on an argument right now. I think if we can focus on the motion, that would be.
Certainly. Well, this all goes to that motion. In fact, there's plenty for you guys to take in opposing this piece. And so to take advantage of some technicality here at their second bite of the apple to try to exclude the folks who are rightly here to attempt to put their case on for you all, I think is sort of the antithesis of what you guys sit here to hear, which is the public opinion.
Were any of your clients here present at the last hearing? No.
And I'd like a chance to respond to that.
Please, Ms. Wheatley.
There is nothing in the AB article or the Anne Arundel County rules that prevents us from amending an application. We amended the application because we meet the criteria for a transfer of a license. All we had to do was just remove one of the licensees because there was that conflict. It doesn't prevent the board from approving this license now that the application is complete and it meets the criteria for a transfer, and that the only licensee and member of the LLC is that has a financial interest in the liquor license. He does not have any financial interest in any other liquor license in the county or the state or the country for that matter. So, you know, the board has the authority to solely consider the amendment that we're here tonight. And like I said, I think the fact that no one appeared at the last hearing when notice was posted properly, it's effectively, in our opinion, a waiver of their right to testify tonight.
Excuse me. Ms. Wheatley, at this time, we're going to overrule your we're going to, I guess, overrule the motion that you've made or deny the motion you've made at this time. We're going to allow the protestants to put on some evidence. It has been noted that there was a previous hearing and there were no protestants. We're going to ask that the protestants keep it brief at this hearing. So we're not going to go an hour. Counsel, why don't you sit at the table?
We would like the opportunity then to reserve our right for rebuttal.
Absolutely.
And are all protestants subject to cross-examination then?
Anybody who testifies would be subject to cross-examination. Counsel, we're going to be each of your witnesses 2 minutes, but we're going to keep the testimony not duplicative, if that's okay.
We're going to try to fly through all that, and I'll do the best I can to make sure everybody gets through.
And again, you're aware that Ms. Wheatley put on testimony last week, or last month, correct?
I'm not aware of what testimony she put on last month, so I
It's
don't.
available on YouTube, the transcripts are online.
Terrific. Well, I don't get to cross them anyway, so. Yeah.
We're going to turn it over to you, sir.
To me right now?
Yes, sir.
Okay, so she has nothing else to add. Okay, so our, again,
For the record, I don't have anything to add on my direct, or on my case, because we had put it on last hearing. So as I understand it, we're moving to the protestant's case, and I will have a right for a rebuttal.
Correct.
that sounds right. So, again, I'm here and I'm on behalf of Doc and Annie's Liquor Store. They are here protesting the transfer of the BWI Deli and Liquor Class A license to the liquor outlet Glen Burnie. With me today is Harshil Patel, owner of Doc and Annie's, and along with what I understand to be 9 petitions in opposition that were filed with this board. And we also have 443 community member signatures protesting this transfer application. One of the things that I was...
I'm going to object. I don't understand what he's talking about as far as a petition with signatures. We weren't made aware of any of that. I'm not sure it was presented to the board.
Has any of that been
prior to
submitted
the
into
hearing.
evidence?
we have it right here for you. We can give you.
We would need it to be submitted into evidence.
And we're sure going to do that.
Counsel.
Yeah. And there wouldn't have been an advance thing for her either. So when we get into this, again, the difference between the BWI deli liquor license and where they're going here is pretty dramatic whenever you look at it. And that's why these factors of new license considerations are required to be considered at this stage of a transfer. And, I certainly from a case law perspective, that is something that's been highlighted time and time again. For example, BCLBA v. Kwan case, which I'm pretty sure everybody's familiar with, is one that expressly says that when we do the transfer, you have to require these factors to go through. So one of the things I'd like to introduce here is Harshil, and I'm going to use his first name because I think there's a handful of Patels in the room, and I'd like you to tell me a little bit about your business and yourself as it relates to this.
Good evening. My name is Harshil Patel. Been the owner of Doc and Annie's for the past 18 months, so pretty new into the business. Since I took over, I've invested quite a bit of money into the store, into the community, and the customers that we serve. We've done extensive renovations to make sure everything is good to go compared to the previous ownership. Chairman, you probably remember the previous ownership had plenty of violations. We've made sure to not get any violations in the past 18 months. In fact, we had our inspection last Friday, and we were good to go. And before that, we had an underage sting operation, which we passed. We received our letter from our inspector last week as well.
And so what we're going to be looking at here today is demonstrating that there is no public need that's being satisfied
Counsel,
by...
is this opening
Yeah,
argument
is
or
there a
testimony?
question here?
Just very...
We're giving our presentation here. He's going to jump in and out as we're going through. If you'd like me to do by proffer, I'm happy to do that.
If he's going to be a witness, I think you should ask him questions. If you're going to proffer, you can proffer.
Okay, so...
Can I object to a proffer? He has witnesses. He can ask them questions.
You have
if he wants to
witnesses and you
put-
have and stuff too. Proffer happens all the
I'm
time.
going to sustain the objection.
All right. Mr. Patel, you talked about where is your location?
Sorry, can you repeat that?
Where is the location of your place?
Right in Brooklyn Park, 5920 Ritchie Highway.
In the past 12 months, have you seen an increase or decrease in your sales?
Dramatic decrease.
Okay, and how about this? Have customers been complaining about any of your selection or anything?
Objection, leading.
Sustained.
This is an administrative hearing. Leading questions are permitted. The whole last presentation were all leading questions.
Violation dockets.
How is that different than the presentation that we're giving you here today? That doesn't change the rules of evidence.
Counsel, I've made a ruling.
Okay. What, if any, complaints have you had about the selection you've at your liquor store?
None at all. In fact, when customers request anything special, we have a system in place that we can order it for them, and then it will automatically text them once it's in. We'll let them know that they can come pick it up.
Have you had any indication that your store, the stores around you, aren't meeting the needs of the Glen Burnie community?
Objection, leading.
I'm going to overrule the objection.
Not at all.
Harshil, you worked on gathering a petition from local community members, isn't that right?
That's correct, me and the other nearby stores as well.
And did you put that petition together with collaboration, or did you write it yourself? Where did it come from?
I looked at the last petition we had done for Sip and Learn Wine and Spirits and took a lot of things from that and then formatted it.
Do you have that petition with you today?
Yep. They're all over here. You want mine or from the other stores?
So I have yours here that I have a copy of.
And these are from the other stores.
Okay.
Copy of these.
Okay. So we have one copy of the petition that's been collected by all the stores that are here testifying tonight. I have one copy of that. I have 7 copies of the one that my client here put together. Would you like the one original that has the 400 some odd signatures for the record?
Council, our rule typically is that we require 5 copies of any document submitted.
Okay. So what we're going to do then is we're going to submit the one that we have from my guy, and I have 5 copies, and I have 7 copies for you. So I have a copy for you here. Gave you a copy.
I'm going to object on the record. This is a signed petition of people that aren't here. They haven't decided to be here, or any of them appeared at the February 10th hearing.
We're going to admit the document, but it's going to go to the weight, Ms. Wheatley.
Thank you. Herschel, can you explain to me how you gathered these signatures on this petition?
We set the petition at the checkout counter. We actually didn't ask any customers to sign it. We waited for the customers to ask us what this petition was about. And once we explained it to them, they were more than happy to sign. Because as stated, there's already an oversaturated market. And there's a liquor store less than half a mile from the proposed site.
Mr. Herschel, are you familiar with how many licensees are within a 5-mile radius of this location?
Yes, I believe there's 33 licensees from.
And how do you know that?
I actually pulled that from the county's list and then mapped each and every license against the proposed location. Okay. So from the Anne Arundel County Liquor Board's database.
Okay, is this that map that you put together?
That is correct.
And this is the list of the people on the back?
Yes, that is correct.
And the distances from the location?
Yep, driving distances and straight line distances.
Is this document being moved into evidence?
Yes.
So admitted.
I'm just going to note an objection to the extent that it's, again, wasn't presented at the last hearing. It's comparing a separate class of licenses as well as a Class A, and just noting my objection.
Thank you, Ms. Wheatley. We're going to admit it, let it go to the weight.
Are you familiar with anything that the liquor outlet is proposing to sell?
Objection, speculation.
Sustained.
Are you familiar with the type of license that liquor outlet is seeking in this transfer?
Class A license.
Okay, and are you familiar with what type of beverages that allows you to sell?
Beer, wine, and liquor.
And what is it that you're allowed to sell?
I have a Class D, but I have on and off. So for off premises, I'm allowed to sell beer, wine, and spirits.
Are you how many total Class A licenses are within the 5-mile area?
I believe there are 25.
Marshall, are you familiar with the physical location where the liquor depot is going to be, or the liquor outlet's going to be?
Yeah, I actually go there multiple times a week to get gas at the Costco gas station. And the reason I hadn't seen the sign on the building was because of the snowstorm that we had, and they had piled up snow very high in the parking lot, and you couldn't see from the street to the building where the glass is. So once the snow started melting, which was after the last hearing, that's when I noticed the sign.
Are you familiar with any places of worship within the general vicinity of this location?
Yep, right across the street, there is a church, called Lighthouse Church, and that church is within the 1,000-foot rule.
Objection.
How? Okay.
How does he have the expertise to make that ruling? And we've also presented a site plan to the board that's in the record that demonstrates the property is more than, the entrance of the property is more than 1,000 feet from the church.
Sustained.
Okay. We actually. Okay. Hashil, did you walk, you're familiar with where that church is?
Yes.
And you walked to the front door?
Yep.
Okay. What did you do?
I'm going to note a continuing objection to the distance of the church. We've
Council,
already
site plans.
established.
And it's not expert testimony. A person can walk 1,000
Something
feet
that's
and count.
checked when the application is filed.
I'm sorry?
This is something that's verified when the application is filed.
We have his math piece here that shows exactly how he did it and how he calculated it to be able to show that this space is within 984.6 feet of the front door to front door. It's within the 1,000 feet of the church.
Based on his calculation, it's not.
Not my calculation, I did it through Google Maps, Google coordinate to coordinate.
I understand the concern, Council. There's more verification that goes on than just taking the licensee's word. There's a site plan that's presented in the application where that's measured. Correct.
Okay. So again,
So 1,000 feet has been, that issue's been resolved.
Okay. Thank you, sir. Ashok, is there anything else that you would like to tell this board here today about, about the impact on your store should they grant the transfer of this store?
Objection, it's an open-ended question. I mean, you can ask him something specific.
I'm going to overrule the objection.
I don't have to tell you what would happen if a 7,000 square foot store gets added into an already oversaturated market. Plenty of businesses, when we came and gave testimony last time for Sip and Learn, that establishment was way smaller, and we proved back then that there was not a need. Our customers had signed petitions saying that there isn't a need for a liquor store. They themselves, members of the community, don't want a liquor store, another liquor store. This BWI Deli and Liquors is not part of the current community. It's not part of the market area. We're essentially bringing another license into the area, which is basically the same as adding a new license. So sales would continue to go down in an already struggling market where we have to compete with marijuana. The youth are moving to marijuana dispensaries, right? So our sales are already declining because of that. Alcohol consumption as a whole is at the lowest level since, in the last 50 years, from what I was reading, right? I have data here, but at this point, I've been thrown off so many times, so I'm just.
What you just referenced, do you remember reviewing the Gallup poll on the reduction of drinking rates?
Yes.
Objection.
Overruled, I'll allow it.
Okay. And is this the report that, or is this the study that you were talking about in terms of the lowest of all time?
Again, objection. He's testifying to a study that he didn't create or have any part in taking, the data for.
Counsel, if the question's about his personal knowledge or belief about this, we'll allow that testimony. But to him to read an expert report that isn't in evidence, Not going to do that.
He's not going to read it. He's not going to read it into evidence. I'm just going to give you a public Gallup poll showing it, backing up this piece. Because at the end of the day, it's what it does is directly counter the traditional evidence that's presented in terms of populous growth. Now, populous growth doesn't necessarily apply anymore when we're talking about a 12% overall
Again,
reduction within
he's
the past 3 years.
testifying at this point. He has no expert to put on this evidence. He's discussing a public poll that could be subject to dispute, and no one here to support the data that's inside of that.
I have public information right here that's published.
Document speaks for itself, counsel. You can introduce it into evidence if
That's
you like.
what
Your objection is noted, Ms. Wheatley.
Are you familiar with the Sip and Learn application
Yes.
from January 1, 2025?
Yes, I was here to.
Objection.
Counsel, where are we going with this?
We're showing that a liquor store application within 1.5 miles of the proposed location was
It's a
denied for no
totally-
public
A
need.
totally unrelated application for a new license that was discussed over a year ago, and it has no bearing on this case.
Well, I would
Counsel's
say,
not controlling. We're going to sustain the, I'm going to sustain the objection.
Right, I think that's all I have for Mr. Harshel, and I would reserve for my closing, if you'd like to cross him.
Ms. Wheatley?
Sure, just a few questions. Mr. Herschel, did you appear at the February 10th hearing on this matter?
No, ma'am, like I mentioned.
That's just a yes or no question.
No.
Thank you. And you stated that you operate a Class D license, is that correct?
That is correct.
Okay, so that allows for on-premises consumption of alcohol, correct?
On and off.
Okay, so a little bit of a different business model than a Class A license, is that correct?
Not necessarily.
Okay, but a Class A license would not allow for on-premises consumption, is that correct?
That is correct.
Okay. And you yourself did not compile any data that was gathered in the Gallup poll that was just presented to the board, was there?
That is correct.
No further questions.
Mr. Brown?
No redirect for him. I represent Doc and Annie's, and I know there's several other places here. How would you like that? Would you like that testimony to come through now, or how would you like to proceed with those each individual people?
We're going to keep it brief, but
If I can briefly make a comment, if he's entering his appearance on behalf of Doc and Annie's, he can represent Doc and Annie's, but everyone else can testify for themselves.
Again, I don't have a problem with that. I'm just trying to be as efficient as possible, and it'll be more efficient if I run it, but
we're going to keep
Godspeed.
redundant testimony to a minimum. So if anyone starts to get into that redundant space, we'll just indicate that there's however many people here in opposition, and we'll go from there.
I think it's fair.
Otherwise, we'll give the next person 2 minutes, and we'll keep going until it becomes redundant, and then cut it off.
Would you like to introduce yourself?
John Christopoulos, Christos Discount Liquors. We've been in business for 64 years.
Okay, Mr. Trump. Are you familiar with the general area that we're discussing here in terms of the liquor outlet in Glen Burnie?
Absolutely.
Okay, and what is your understanding of the impact of this particular transfer license, should it be granted, on your store?
Mr. Brown, are these individuals testifying individually, or do you
Here's what we're gonna do. I'm gonna close out my stuff and let them go, and then you guys can keep it that way, and that'll give everybody the 2 minutes.
just trying to keep it as clean, that's all?
You got it.
You want to, yeah, just limit it to 2 minutes per person.
2 minutes per person, correct. Thank you. Mr.
Well, you discussed the sip and learn, so I know I can't bring that in, but I testified with Mr. Bittner back in January. It was saturated then, it's saturated now. I know, I'm familiar with the BWI Deli, and I didn't impose that. And it's closer to me than this location, and because that's an undersaturated market. So I'm not here, there's no ill will towards this individual, but he's moving, and I'm unfamiliar, you're allowed to transfer. Because when we moved directly next door years ago in '99, and I had to apply for a new license. So technically, this is a new license going to another area in the county or in the Glen Burnie area. So, and they may meet all the qualifications, but they're just never going to make it. They're just, the location, that's my opinion. It's saturated. The stores are struggling. The business is down $830 billion in the last 4 years. The trends are not good. I'm ex-Gallo. I've been 64 years. I've been president of the Beverage Association. I've been on the board of the Anne Arundel County Licensed Beverage Association. I'm the expert. I know what I'm talking about. You can say all you want, they won't make it. And then if next year chains come in, that license is over because Costco's coming in. Who's the biggest retailer in the nation? Costco. So you put them in, will they have much impact on me? They won't. Because I'll just lower my prices and I'll try to put them out of business, just like I do everyone else. So, but they're not going to make it. The square footage is probably $25 a square foot, which is about $14,000 a month. That's so they won't make it. If Sip and Learn wouldn't make it, and you disqualified them, why do you think these guys will make it? That's what I have to say.
Ms. Wheatley, do you have any questions?
One question. Did you appear at the February 10th hearing on this matter?
I was in Jupiter, Florida. Sorry.
So I know there's a handful of other folks that are going to speak on their own here, but I'd like to sort of wrap up at this point. I do think, even though you said it's not binding on you, Sip and Learn does matter here. And when we look at the
I'm
comparative,
confused on what we're doing here. Are we allowing people to testify, or is he making a closing argument?
I'm going to make a closing argument, and the other folks who are randomly back there are going to come up and talk.
Why don't you do your closing argument after they testify?
Fair enough.
Thank you.
Hello, everyone. My name is Julianne Sullivan. I'm the president of the Anne Arundel County Liquor Board Association. We are here in opposition of this. The main reason is we would have absolutely no objection if the license stayed at its current spot. But we are in agreement that moving to this new location is in an oversaturated market, as everyone else has said. As they have also said, and anybody in the business knows, liquor sales are down. We are all struggling. I was not here, and the board did not come before because unfortunately, we were not aware. There was the signage up, but as others have stated, there was the snowstorm. We weren't paying attention, and no one paid attention to logging on and looking at this. So that is on our fault. And the new location is also taking a license from a place that is approximately 1,000 square feet, I believe, or maybe smaller, to almost 6 times more. So if they wanted to stay maybe in their same location and try and find something, we would look at reconsidering that. But to move a license that's not even 1,000 square foot business to an oversaturated market that is over 6 times the size of where the license originated, we oppose this as the association.
Ms. Wheatley, do you have any questions?
No, she answered my question about whether or not she was here on February 10th. Thank you.
Thank you, ma'am. Sir?
Good afternoon, members of the board. My name is Amar Sethi. I represent Buzz Liquors, and we have been serving the community since 2019. I would like to express my concern regarding the proposed transfer of the liquor license on Ordnance Road near Costco. This area already has a significant competition, as you heard before, and the market has been going down as well. Being in the business for over 6 years, you see that day to day. My liquor store currently carries over 5,000 different SKUs. As Herschel said before, if a customer needs a product, we can get it to them. We have the Beverage Journal. So bringing something new to the market, we can already do that. consumptions are down, younger generations are doing different trends. And because of this, many existing stores are already facing increased pressure on sales. Now, as someone else just mentioned, that a store going from 1,000 to 6,000 square feet is a huge difference. My store currently is around 2,000 square feet. So if a store came 3 times bigger than me, it would really cause problems on us and our business. I please ask you to consider not doing the transfer. And to answer her question, I was out of town that day too. That's why I'm here today.
Thank you, sir.
Thank you.
I just have one question. I'm sorry, remind me of your name again.
Amar.
Amar.
Yes.
Mr. Amar, is it accurate that your liquor store is roughly over 2 miles away from this location? Is that correct?
1.5.
Okay, but from entry to entry, not taking roads or anything, just directly, what do they say, as the
If
crow
you want, I can
flies?
check that really quickly. I
Okay.
can, to be exactly precise.
Okay, so if I check the Anne Arundel County GIS mapping system and I calculate it as 2.3 miles, is there any reason to believe that I'm incorrect?
Even if it is, it's still going to impact my
Okay,
business.
just
Yeah.
yes or no, thank you.
Yes.
Any other
No further
questions, Ms. Wheatley? Thank you, sir.
Thank you.
Good evening. My name is Parash Patel. I own Klaus Liquors for the last 20 years. I was here a year ago testifying against the new licensees. As everyone said, it's oversaturated market. We're definitely will see a decrease in the area. I go to Costco every week, and I did not see that sign, even though I get gas and come out, and that's directly to my vision. So I did not see the board. If I did, I would have brought it to the organization, which I'm a board member of, ahead of time. And I was not here on February 10th because I wasn't aware of it.
Ms. Wheatley, any questions?
No questions.
Thank you.
Thank you, sir.
I'm Shiri Sherpara from Chesapeake Liquors in Glen Burnie, 6720 Ritchie Highway. And I just doing business from 30 years. And we have so many competitions already there, from 30 years. And so many establishments came to get new business open, but everybody failed. We went against, nobody opened it. Right across from our, like in a Target shopping center, same thing. Nobody opened it because you guys didn't approve it. So we don't need no competition. We are already suffering right now. We got so many stores behind. So please, consider that and would be appreciated.
Ms. Wheatley, any questions?
I'm sorry, I didn't know if he had testified to this or not, but Mr., did you appear at the February 10th hearing on this matter?
I'm sorry, no,
You
I
did
didn't
not?
know.
Yes
that.
or no?
I didn't know.
Thank you.
Thank you, sir.
Hi, sir. Shiri Sherpara. It was second page, I think, second line. Yeah, that's my home address. Okay, thank you.
Okay, thank you, sir.
Mr. Brown, did anyone else want to testify or just indicate that they echo the same sentiment?
Vijay Patel, representative Burst Liquor, 6023 Ritchie Highway, Brooklyn Park, 21225. This is a already saturated market in this area. It's so much establishment, people has enough choice and everything. And this is a huge store. If considering from 1,000 square foot to 6,000 square foot, it's going to huge liquor store coming in our area. And business is going down. Everybody's struggling right now. So my consideration is to
do not grant that liquor license.
Ms. Wheatley, any questions?
Did you appear before the board on the February 10th hearing regarding this matter?
No, I'm not present that time. I'm out of town.
Chairman, if I may, Chief, there's a question about the posting that's come up a couple times. Have we verified that the posting, has it been verified in terms of when it was posted?
The original case was posted properly 10 days prior to the hearing.
And for the record, we did submit an affidavit prior to the February 10th hearing and this hearing that the sign was posted properly and provided the board with photos of the posting.
Thank you.
So the first sign posting was done by Inspector Jeremy Fisher.
Any other witnesses or anybody who'd like to echo that the common testimony that's come up?
So hearing none, I'll sort of jump into the closing here and looking at these, if there's anything
Well,
else.
I would,
We have rebuttal. Do we do that?
well, I think the closing argument goes to you, Ms. Wheatley, first, because I guess technically the case is yours today. And then it would go to Mr. Brown.
Right, but we
and then-
reserved our right to present rebuttal, so I have
you.
an expert here to present rebuttal testimony as to all of the issues that came up in the testimony.
Did you want to bring the expert up at this time?
Yes.
Thank you.
The applicants will call Mr. John Aronson.
So you've been previously sworn at the last hearing. Did we swear him?
I swore in again this evening.
Thank you. Ms. Wheatley?
Thank you. Mr. Arison, have you received a copy of the written opposition that was submitted in advance of this hearing?
Yes, I have.
And have you reviewed that opposition?
Yes, I did.
Okay. What district is the existing license in?
Assessment district? It's
Yes.
number 5.
And what assessment district is the proposed location for this license?
Number 5.
And how does this transfer affect the quota for the Class A liquor licenses in Assessment District 5?
There'll be the same number of licenses if this is granted after than there are right now.
And you heard the previous testimony as far as the argument that there is an oversaturation of the market, is that correct?
Yes, I did.
Okay. And did you review the Gallup poll that was provided to you, that was submitted to the board tonight?
I just sort of looked at it while I was sitting in the audience.
Okay. And the general concern is that alcohol consumption is down. Are you aware of any data or reports that would contradict that statement?
First, I'll say Gallup didn't ask me. I looked at comptroller data, and it's kind of up and down, month to month, whether between 24 and 25 if sales are up or down or up and down. So, you know, I'd have to say this is probably fairly level. I looked at another website, parkstreet.com, that tracks these things, and they noted that between 2019 and 2023, the sale of spirits was up 3 1/3%, wine was flat, and beer was down 2%. So, I mean, I don't know if you can blend what's happening across the country and say and make it specific to one area, but you know, maybe drinking is down.
And what is your understanding, or how would you characterize the population of North Anne Arundel County?
Well, it's fairly dense. It's a suburb of Baltimore. Although the location that's proposed for this license, nobody lives over there. So I wonder, with a petition, I don't think that a liquor store here is going to impact any resident because there aren't any residents, especially not within 200 or 400 feet. I think that what the store is banking on is a traffic count from the Maryland annual average daily traffic from MDOT, just west of the intersection that turns into the shopping center. There's 32,000 vehicles average daily trip. Once you get through that light, it drops down between 5,000 and 20,000. Going further down Ordnance Road where it goes under 695, it's down to 11,000 trips. So at least at a minimum, and the reason why I have to be vague is because they do ranges from 5,000 to 20,000, so it's not fine data. So at a minimum, 12,000 cars are turning at that intersection, and it could be as high as 20,000 cars are turning at that intersection. And all you've got is an industrial park. There's nobody lives back in there. And in terms of the impact, I mean, I live in Annapolis. I live over in Eastport, and I shop at that Costco. If I were to stop and buy some alcoholic beverage, I wouldn't be hurting any store on Ritchie Highway. I'd be hurting Eastport Liquors because that's my neighborhood package store.
No further questions.
Mr. Brown?
You said the BWI store was 1,000 square feet? The BWI Deli, the one that's being transferred from?
I didn't say anything about it.
He didn't say
Okay,
anything.
so you make any comment on the size of these two comparator locations?
No?
Okay, so are you aware that the BWI Deli was only 1,000 square feet?
Objection. For the record, I believe the BWI Deli store is about 2,200 square feet. I could call someone up to testify to that, or we can submit that on the
I'll
record as a
stipulate to
proffer.
2,500 square feet. What, are you familiar with the square footage that's being proposed for the liquor depot? Or the liquor outlet?
Yes.
Okay, and that's approximately 6,000 square feet?
Yeah.
That's approximately 3 times larger.
Well, I don't do math publicly, but I think 6,000 is not 3 times 2,500.
So it is approximately 2.5 times higher?
Like I said, I don't do it publicly. I'll take your word for it.
Well, you're here to testify that there's no impact in this community because it's one A license going to another A license, but these are two dramatically different size stores.
No, what I testified to was the fact that this store could go in without negatively impacting other stores in the area because there are no other stores in the area.
And you said there's nothing else in that other area. You're talking about the industrial complex?
I'm talking about everything east of Route 10.
Okay, and there's a jail.
Objection. I think you're mischaracterizing his testimony. He said there is no residential area.
No residential, but there's a jail across the street from your guy's spot.
Yeah, there's a jail, there's a park, there's an Army depot, and there's some industrial parks.
No further questions.
The applicant rests their case.
Ms. Wheatley, I think it'd be your turn for closing argument, and then Mr. Brown.
You're good. You can go. There's no reason to keep Mr. Aronson here. We're done with him, so no questions for him.
Thank you.
Good evening again, members of the board. Kiera Wheatley on behalf of the liquor outlet Glen Burnie. I just want to summarize some of the points from the February 10th hearing so that we're all on the same page and we can refresh your memory as to why this applicant does meet all the criteria for the new license. Brajesh Patel testified before the board on February 10th that, and he was previously included as an applicant on this license after understanding that there is a conflict with the license that he holds in Baltimore County. We asked the board if we could amend the application, which the board graciously allowed us to do. We removed him as an applicant, and the only applicant on the application is now Mr. Kaushik Patel, who has no financial interest in any other liquor store in the state, county, or country. There is no statute in the AB article or ordinance in the or rules provision in the Anne Arundel County Rules and Regs that prevents applicant from amending the application. Mr. Brajesh Patel testified as to his extensive 14-year experience in liquor stores working as a manager, employee, and licensee. And I point that out to the board because he still will have a role in this liquor store as a manager, which he is allowed to do. He, again, doesn't have a financial interest in the company, but he can assist with management of the license. He began working in liquor stores in 2012, and since then has had no history of any violations. He's a good standing citizen and, very much understands the AB article, the statutes in the AB article, and the local rules and regulations that they would have to abide by. He's made himself very familiar with Anne Arundel County's rules and regulations. He has an active certification in alcohol awareness training. He also testified as to how the business will ensure that the rules are followed and how IDs will be checked. He testified that proper signage will be posted to warn patrons to understands that the licensee and manager and the presidents may have to appear before the board if there are any alleged violations. Mr. Kaushik Patel also testified before this board on February 10th as the applicant and licensee, and pursuant to the amended operating agreement and as reflected in the amended application, he is now the sole member and only individual with the financial interest in liquor outlet Glen Burnie. He is a permanent resident of the United States and the state of Maryland, and he will be involved in the daily operations of the liquor store. Mr. Kaushik Patel also testified as to his 20 years of experience in liquor stores as either an employee or a manager of a liquor license. And also in his role as an employee or manager of liquor license, he has never had any history of any violations. He understands that in addition to the AB article, he has to abide by the Anne Arundel County local rules and regulations, which he has been provided a copy of and is very familiar with. He also testified that he has an active certification in alcohol awareness training. Again, testified as to the procedures that the liquor store will have in place to ensure that all rules are followed, and understands that he would have to appear before this board if any violation were to be alleged. Mr. John Arison, who was here tonight, he was qualified as an expert on February 10th in land use and expert in the Anne Arundel County Code as it pertains to liquor license and the Anne Arundel County rules and regulations. And he was accepted without an objection because no one appeared to oppose his testimony. The testimony that Mr. Aronson presented was widely in favor of the transfer of the liquor outlet at Glen Burnie, and he expressed the opinion that the transfer would be necessary to accommodate the public. I do want to reference again the Kwan case that we referenced at the February 10th hearing that provides the board with guidance as to what public accommodation means. And it is what is convenient, useful, proper for the public in that location. So it's not an absolute necessity. It is what is convenient to the people in that area. Mr. Arison testified that the proposed location is an inline storefront in a small strip center within the confines of a large regional center, which is home to a lot of large retail stores. We've heard about the Costco. There's a Home Depot, PetSmart. Several of these stores are stores that people are not visiting on a daily basis. They are stores that, people from across the county and in other parts of the state are coming to bulk buy items. It's a destination shopping center for a lot of people, either for the Costco or for certain home improvement projects they're having. So it is convenient to them to have something along the stop of errands that they're running to. So, but it's not going to impair the liquor licenses in the immediate area. If anything, it may have some minimal impact on licenses outside of the county. People are still going to go to their neighborhood liquor store. They're still going to visit the place that is most convenient to them. So if they have a liquor store within 5 minutes of their home, on a Friday night when they're hosting a dinner party, they're going to that neighborhood liquor store. They're not driving 5, 10, 15 miles to the liquor store next to the Costco. It's very similar to the McDonald's that's sitting right next to this location. If someone wants to go to McDonald's, they're going to go to the McDonald's that's closest to them. And there happens to be a McDonald's that's right next to the Costco that might be convenient for someone to stop by on their way home. So again, I don't think that there's enough evidence to refute the fact that this is not going to have an adverse impact on surrounding licenses. I ask that the board not give much weight, if at all, to the Gallup poll that was presented. There's no expert presented here tonight on behalf of the protestants who are represented by an attorney or any of the people that testified tonight that Gallup poll is supported in any way. It's just an article that was pulled offline. I also ask that the board not give much weight, if at all, to the petition that was put before them. The representative from Doc and Annie stated that it was a petition that was put in front of their customers at the checkout line. I mean, nearly none of those people, none of them were here on February 10th, and a large percentage of those people that are on that petition are not here tonight. I think the only people we can say if they've signed the petition are the ones that have appeared tonight. So I think it's questionable how they had that petition signed. You know, for all we know, they could just be asking people to sign it. He can make a statement that they didn't do that. We don't know for sure. And without those people appearing and actually expressing their testimony in opposition to the board, I don't think that it should be given much weight. The sign posting is a non-issue in my opinion. It was posted conspicuously in accordance with the rules prior to the February 10th hearing. If someone didn't see it, that is not at the fault of the applicants. You know, we had one person testify today that they just didn't look over there and that was their bad. And, you know, I can sympathize with these people and I'm not trying to minimize concerns in any way, but I think that this is the epitome of a second bite at the apple, that they realized they missed the February 10th hearing and they saw a chance to come back and oppose it when the sole focus for tonight's hearing was supposed to be the amendment that removed one of the applicants from the license. As far as first of all, the transfer to a licensee, the standard is the fitness of the applicant. I think we've more than demonstrated that Kaushik Patel is fit to be an applicant and a license holder. And the testimony about Brajesh's experience and everything, I think, is significant as well because of his role as a manager. Mr. Kaushik Patel has entrusted Brajesh with that role as a manager, and both of them are very fit to make sure that the license is upheld. The transfer criteria for the location is whether or not the proposed location is convenient and accommodating to the public. I understand that the board is going to have to take into consideration the elements, I think it's 4210 or 4203, I can't remember the exact, of the AB article, and that is the public need and desire for the license, which I've stated, I won't go too far in depth, the number of location of existing license holders, the potential effect on existing license holders, the potential commonality and uniqueness of the services, and the impact on the license for which the application is made. I think we satisfy all of those criteria. So whether or not you want to look at this as a transfer or a new license, we meet the criteria. I think you should look at it as a transfer. This is an already existing license in the same assessment district that we are moving the license to. So there is clearly still a need for these licenses in the area. And I think that this particular location is unique. I think it's completely distinct from the sip and learn matter that is constantly referenced. That matter was directly across from the current location of Chesapeake Liquors. It was in pretty much the same shopping center. And again, was an entirely different business model and new license. So I think if I recall the transcript for that, the board also determined that the applicant was not fit to hold the license. So I think that had some bearing on the decision as well. So with all that being said, I asked the board to give weight to the testimony that was provided at the February 10th hearing. And again, while I can sympathize with the testimony that was presented tonight, I do not think that it is should be a subject of the board's decision, considering that they did not appear at the last hearing. I think they effectively waived their right to protest this transfer. Thank you.
Yeah, so we're diving in a little bit to some of the things that were mentioned in her closing. You know, there is no expert required by us. That's the INRI new liquor case specifying about how we are not obligated to come in with data, statistics, or whatever the case may be, and that's not ultimately dispositive on the decision before this board. You know, when we look at some of these things here, you know, there was statements about how, oh, this won't hurt the local folk, we have their expert saying he goes to that Costco up there from Eastport, and from that point, that would hurt his Eastport local store. That's what's going to happen to all of our local stores, and all of our guys here are going to be harmed by folks driving through that part, and you have his testimony to back that up for you. In terms of similarities between these A licenses, you have a teeny tiny deli that sells breakfast sandwiches and some beer on the side going into a giant outlet. About 10 miles away, completely different type of store at the end of the day. So that's the similarities end at A license. When we're looking through the elements that you guys are to consider, and we say, okay, well, look at what you guys have evaluated in the past. Look at what things were presented to you here. Again, sip and learn matters here. Within the past, year, we have 509 people signing a petition saying, don't do that thing. 9 licenses opposing it. Here you have, within 1.5 miles, 9 licenses opposing, 470 some odd people petitioning in opposition to this, showing that this will harm their business. When it comes to the elements that you guys looked at to kill off that application, the same factors exist here. It's an oversaturated market, and they're bringing nothing new. Sip and Learn had something more unique. They were going to teach lessons on wine. That is not even an element here. It is a straightforward outlet liquor store. The public need that we're looking at, again, there was no need apparently for the 2,500 space. There is no need for a 6,500 space. Number and location of existing licensees, 33 existing licensees, 25 A units, all within A licenses, all within 5 miles. In Renew New Liquors, that was 3 other licenses within 3 miles. We have a dramatic increase over the saturation that was found in that case to be supportive of denying a new license. Effect on the license holders. You heard every one of them testify about how this would be detrimental to their businesses. You have the association president coming in saying it would be detrimental to their businesses. This isn't, maybe there's some more competition and the water will level out. This is a death knell to some of these folks. There's nothing unique being presented here that's not already in the community. And, health and safety, again, we presented that a church was there. You guys have stuff that says it's a resolved issue. There's the only sort of concentration of people in that place appears to be a prison. So I think the last thing that folks need to see coming out of prison is a liquor store. So all in all, when we look at these things, there is no need for this place in the public need. So at the end of the day, we have a dramatic change in the social way that people drink alcohol in the past 3 years alone, dropping to its lowest levels of all time. Today, we have a series of small business owners fighting for their lives, not wanting to have to deal with somebody coming in and taking what's left of the business in this community. So with that, I'd ask you to deny the liquor transfer application.
Do I get a last word or as the applicant or no?
Very, very brief, Ms. Wheatley.
Again, I just want to emphasize that the board should be giving weight to the evidence that has bearing to it. They are constantly referencing a trend and a situation that they have no expert testimony or supported evidence that lends itself. When I read the testimony of the Sip and Learn case, there was a mention that no expert was provided by the applicant to support the license and that the applicant was not fit to hold the license. In this situation, we have an application that meets all the criteria. They have an expert here that testified that there is this trend that they're talking about is not as supported as they keep shouting it to be. And this is a group of other license holders that want to prevent people from having licenses. Again, I can sympathize with the business model, but the facts are the facts, and the application is supported by expert testimony.
Thank you, Ms. Wheatley. I believe the board's going to issue a written decision on this one. Thank you.
Thank you, everybody.
Is that
Thank
it?
you for your
We're
time.
ending then? Okay.
Okay, you can call the next case. But our next case will be for Toro Bravo, Inc., trading as Toro Bravo, Milagro D. Hernandez, President, Inspector Latasha Beckles. This is for a special permit, upgrade to entertainment, multiple TVs only, and a trade name correction. Currently, Milagro Hernandez, President on behalf of Toro Bravo, Inc., trading as Toro Bravo, El Toro Bravo, located at 802 Pinnacle Drive, Suites 107 to 109, Lincoln, Maryland, 21090. This is a Class H restaurant with VWL music, Sunday license with outdoor service. There's currently 2 restrictions for hours of operation, Monday through Thursday, 11 a.m. to 10 p.m., and Friday, 11 a.m. to 2 a.m., Saturday, 8 a.m. to 2 a.m., and Sunday, 8 a.m. to 10 p.m. And the second restriction is only 1 TV is permitted under a special music license. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand, please. Thank you. You solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Please be seated. Starting from my left, please state your name and address for the record.
Go ahead. Well,
You first, sir.
okay, thank you. My name's John Gardner. I'm here as counsel for Toro Bravo.
Thank you, sir.
Thank you.
My name is Milagro Hernandez, 1002 Stain Road, Glen Burnie, Maryland, 21060.
Thank you. Mr. Erdl?
For the record, Ms. Hernandez is the licensee.
Wonderful. Thank you. Sir, I'll turn it over to you.
All right, well, thank you, Mr. Hurdle. First, I would like to formally offer into evidence the exhibit list, which I sent sometime in January. I'd like that I'd offer that
So
admission
admitted.
into evidence.
So admitted.
All right, thank you very much. With the board's permission, I'll proffer.
Please.
But what we have here is 2 issues. One is a special permit for additional TVs. There was one, and I understand from the inspector that when she discovered that there were additional TVs that had inadvertently been installed before I was involved in this matter, they then came to me, and so I began addressing this issue to get the board's approval for the additional TVs. There would be 4 or 5 in the bar area and 1 in the dining room area, as proposed and requested. And I think everybody recognizes that even in restaurants, and especially bars and restaurants, sports are a big attraction, and these TVs provide that. All these sports, more and more sports all the time. So I think it certainly warrants approval for that that reason. And the other issue is for the clarification or correction of the trade name. I think there was some question in the board's records that there was El Toro Bravo or Toro Bravo, and what was the trade name? And one of the exhibits I have, which is my letter of December 17th, 2025, it clarifies what the trade name of the restaurant is, which is Toro Bravo Mexican Restaurant. There is another El Toro Bravo 2 on Riva Road, and that might have caused some of the confusion. There's also one in Annapolis City, El Toro Bravo, the original. And they do have some of the same ownership, or related ownership. So that may have caused some of the confusion, so we wanted to clarify that, as well as make the request for the additional TVs, which I think lends itself, as I said before. So I would ask for the board's approval for both the additional TVs and for the correction or clarification of the trade name. Thank you.
Mr. Chairman, any questions?
No, actually, I don't have any at all. None.
Thank you.
Commissioners, any questions?
Anything else you'd like to add, Mr. Gardner, before?
No, Mr. Chairman, I would just ask for the board's approval of both those items.
Okay, I'm going to go ahead and make a motion that we do approve it, the multiple TVs, as well as the clarification of the name, and it is Toro Bravo Mexican Restaurant.
That is correct, Your Honor. Toro Bravo Mexican Restaurant.
All right. Now, I got to go home and listen to my wife say, "I'm not calling you Your Honor."
Did I say that again?
You did, and I heard it the last time. So, but anyway,
Your
thank
Honor,
you.
I'm according you respect.
Well, I'll take it.
Mr. Chairman.
Thank you.
My mistake.
No, I get a kick out of it because of what she made me go through. But anyway, I am going to make a motion that we approve everything that you're asking for, which is the trade name correction as well as the multiple TVs. upgrade. I'm looking for a second.
I second.
I have a second. All in favor?
Aye.
Aye.
Aye. Thank you. Have a good day.
Thank you
Lots
very
of
much,
luck.
Mr. Chairman,
You're welcome.
members of the board.
Our next case is going to be for 177 Pasadena. Thank you, Ms. Carter. Anyone wishing to testify for or against 177 Liquors, please come forward, remain standing, and raise your right hand.
You notice tonight I at least let you say the numbers first.
Much appreciative. Sir, can you raise your right hand, please? Do you solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please be seated. Can you please state your name and address for the record?
You can stand.
Yeah. My name is Zahiz Jaffrey. I live in 3524 Water Place, Laurel, Maryland, 20724.
Thank you. You can be seated, please.
Thank you.
Mr. Arundel?
Ms. Carter?
Thank you. Good evening, Mr. Chairman, members of the board. With the board's permission, if I can do this by proffer, we have filed an application for transfer with this board. My client and his partner are buying not only the business, but also the real property, subject, of course, to approval tonight. My client is currently a licensee on a Class B plus license in Prince George's County. Other than that, he has no interest in any other business establishment, any place in the United States or the world that has an alcoholic beverage license. He understands the board's rules and regulations. He understands that if a violation occurs, this board is going to hold him responsible. I am pleased to tell this board in all the years I've known him, 7 or 8?
Yes.
Yeah. There's never been a violation in which he's been involved. At this point in time, there is no planned changes in either the mode of operation or in the employees. They're all going to be offered the opportunity to stay on. We understand the restriction that everybody who's involved in the sale of alcohol has to be alcohol awareness certified. And my client will make sure that happens pursuant to this within 45 days of hire. And we would ask that that be modified within 45 days of the settlement date with the board's permission, because some of these people may have been hired and maybe aren't certified and we don't know.
You understand under the rule changes, though, that everybody in a Class A
Absolutely.
who works the point, I want to make sure he does as well.
Oh, I
That
apologize.
everybody at the point of sale must be alcohol awareness trained.
Yes, sir.
But what your attorney is asking for is a stay, if you will, or a grace period of 45 days. Am I reading that correctly, Ms.
That's
Carter?
correct, Mr. Chairman. So tentatively, we're hoping to settle on the 15th. That may or may not occur. There are some issues that need to be resolved prior to the time we can confirm that date. But I would ask that we be given just to the end of April to make sure that everybody is actually compliant, because I can't tell you right now that everybody is. I just can't make that representation.
Yeah. I think you're asking a bit much for the 45 days, but we have a new program that's available. And I'm not quite sure what the bookings are, but I know there's at least one class available each and every month for the next 3 or 4 months to begin with. What I would suggest you do is check, and I'm sure the president general manager would let you know who is alcohol awareness trained.
Yes.
I'm going to give you, because you are new at this and because this is a fairly new rule that's just went into effect, I'm going to make a motion that we do accept the transfer. And at the same time, I'll grant you a 14-day period. And I believe that would be sufficient for you to make sure if you have any of your point of sales people that aren't alcohol awareness trained, that you should be able to get it done. And you can check with our staff with the liquor board, and they can help you out with a list of alcohol awareness programs that are available to you, as well as the new one that's out now. Okay.
So, Mr.
Anyway,
Chairman-
my motion is to go ahead
May
and grant
I
the
have a
transfer.
question, please, because one of the things that when I read the rule, I didn't look at thoroughly is, do you need certification or do you need training? And the reason I ask is the online classes are training, but they're not certification under Maryland law unless it's the Frederick County program.
Okay. Our chief could speak to that more directly. He's been involved in it, so I'm going to turn it over to him, and he understands what we've done.
Yeah, so there, to my knowledge, I know there's 3 online programs that are certified in the state of Maryland. One is the Frederick County program. Another one is the RAM program through the Restaurant Association of
Oh, is that
Maryland.
now? Okay, thank
I
you.
believe there's an R-serving program currently that's certified. There is a new program that we've worked in partnership with the coalitions, substance abuse coalitions called PASS. There's I think March 20th is the next date that's available. We could provide you that information later. Obviously, there's TIPS, there's TAMS, there's a bunch of other ones too, so definitely have options.
Yeah. No, I was asking though, if you take an online class and take the test, does that satisfy the board's requirement? Or, okay, Mr. Hurdle is saying no, and that's the
Yeah.
answer.
They
That
have
was,
to be
that,
certified.
I'll be honest, that's what I would agree, but I needed the clarification. Thank you.
Tests have to be proctored in person.
Okay.
Okay, very good. Anyway, motion stands for accepting the transfer. I'm looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye. Very good.
Understood,
Thank you.
and thank you so much.
Okay,
Y'all
you're
have a
welcome.
great and safe evening.
Take care.
Our next case is going to be for Cooper's LLC, trading as Cooper's Tavern.
Waive reading.
Thank you, Mr. Lyman. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand, please. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Starting from my left, can you please state your name and address for the record? And Mr. Fulton.
Mark Fulton.
Thank you. Mr. Lyman.
Thank you, Chief. Brian Lyman, Lyman, on behalf of the applicant.
Are coming back there, 3354 Eastern Road, Edgewater, Maryland.
Thank you. Ms. Erdl.
Mr. Lyman?
Thank you, Mr. Chairman.
Before we get started, I just wanted to bring up, there was a notice of some debt, I guess an amount of
Your
judgment.
microphone. I'm sorry.
Sorry, there was a judgment indicated against the seller of this location.
Well, thank you, Mr. Hurdle. I wanted to address that same thing with the board preliminarily.
If I may, Rule 2.14A indicates that we're not supposed to have a hearing for the approval on this. 2.14B indicates that we cannot transfer the license if there's this judgment. I think is it my understanding you're looking to waive A, and therefore B would apply, and therefore the license could not be transferred, but we could hold a hearing and approve it, but the transfer would ultimately be held up. if there's
Mr. Hurdle,
judgment.
that was part of our sort of preliminary discussions and negotiations. However, we have not reached any accommodation on that, so I need to respectfully request a postponement of tonight's hearing so that further discussion in relation to the claim that my client frankly found out about today can be made. So as to avoid prejudicing his application, that is the preliminary matter, and I do, on behalf of the applicant, request a postponement of the transfer hearing that was scheduled for tonight. We do acknowledge that if the postponement is more than 60 days, that Mr. Yerkley will need to pay the cost. That's in the board's rule 2.11. He understands that and is respectfully requesting the board to postpone his application so that we can discuss an appropriate accommodation with the creditor who has asserted a claim today.
Thank you. The case is postponed.
Thank you, Mr. Hurdle.
All right, our next case is going to be for Turkey JBLI LLC, trading as High Tide Grill.
We can waive reading.
Thank you, Mr. Lyman. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Please be seated. Starting from my left, can you state your name and address for the record, please?
I can't hear him very well. My name is Brian Lyman, Lyman, on behalf of the applicants.
I'm Donald Neuenberger.
Address, please.
Yes, sir.
You state your address, please.
By occupation?
Address.
Address. Oh, I'm sorry. 4245 Kings Road, Edgewater, Maryland, 21037. And just to make sure, my last name is spelled wrong on here.
Our apologies. Sir.
Ivanos Caro, 102 Winchester Street, Chester, Maryland, 21619.
Thank you. Mr. Erdl?
Thank you, Mr. Hurdle. Mr. Chairman, Commissioners, We're here to present an application for a transfer of a restaurant license. This is to be known as High Tide Grill. This perhaps rings a bell in the board's memory as a fairly contested application when the restaurant originally received its license as Harper's Waterfront. I have the pleasure to say that the new ownership group has asked Mr. Neuenberger to stay on as the continuation thread and the qualifying applicant. He's granted a minority interest in the LLC, which is known as Turkey JBLI LLC. I believe that all of the documents and paperwork that have been submitted and I believe corrected in the interim remain correct. And I would ask the licensee or the applicants to affirm that for the board and to recertify that all of the representations made in those documents are still true and accurate. Is that correct?
That's correct.
Okay. The concept for the High Tide Grill is a bit different from Harper's Waterfront. The applicant seated to my far left is Ivano Scoto. He's operated and been involved in several restaurant ventures over his career with great success, and he is familiar with the rules and regulations of this board. He absolutely understands what's required of the privilege of selling alcohol. This is a particular property that's located across the water from residential properties. And as Mr. Neuenberger knows and has explained to the rest of the potential incoming ownership group, they need to take their responsibilities as neighbors seriously. The board has placed restrictions on this license as to the bar seating and the restaurant seating. There are 32 outside seats and 12 seats at an outside bar. And I have certainly warned the applicants that they need to pay special attention to training their staff appropriately to try to limit the amount of noise that travels across the water to reduce any impact on the community. Notwithstanding, the board saw fit in order to approve this license previously at this location. It's at 1107 Turkey Point Road in Edgewater, and it's actually mostly on the second floor, although there is some storage area for alcohol and cold storage on the first floor, which is also part of the licensed premises that the board approved previously. I believe that the floor plans are all clear and make clear to the board that there are no real substantive changes to the layout of the restaurant itself. The branding, the menu options, those will be relaunched as High Tide Grill, and the new restaurant concept will launch. And I would certainly open up to Mr. Scoto if you'd like to share any of the details or restaurant accommodations that will be made for the public that your group plans.
Yeah, for sure. Mr. Harper, sitting behind me, definitely built a beautiful, gorgeous spot. And we plan on just continuing to operate it in a very responsible manner. The restaurant is going to take a little notch down as far as like how high-end it was prior, but nothing, nothing to vary too much from there. We've got a new menu going, and we're rebranding it to something a little tiny bit more casual than before. But other than that, it's going to stay fairly the same.
The hours of operation, the staffing requirements, the parking and all of the facilities have been found to be adequate. And we ask the board to certainly ask any questions you might have of Mr. Scoto. He understands the responsibilities. He's been a licensee before this board. He is a fit and proper applicant. And I have next to me Mr. Neuenberger, who's the current licensee, who will become the licensee for the High Tide Grill should the transfer application be approved and the closing happen.
Chairman, any questions? Commissioners, any questions?
On effect as written with the seating and so forth. I'm going to go ahead and make a motion that we accept the transfer and agree to it. Looking for a second.
I second.
Have a second. All in favor?
Aye.
Aye.
Thank you very much, Mr. Chairman, Commissioners.
Thank you very much.
You're welcome. Have a good day. Thank you.
Thank you all very much.
Yeah. Just We're going to take a 10-minute recess before we start the last, which is the Blair, London protest hearing. So 10-minute recess. Thank you. No? You let me know when. Okay, we're good? Okay, we're going to call this hearing back in session. The case of Dilligaff's Pub, S&S Business, Inc. This is a remanded case, currently Blair's London Town Pub and Grill, LLC. I'm going to go ahead and turn it over to our attorney, and we'll go ahead and begin.
Thank you, Mr. Chairman. Bruce Cohay filling in for Mr. Arundel, who is out in this case. Mr. and Director City Council, can you state your names for the record, please?
Mr. Winter Bartlett LLC representing today I guess she's the respondent, I don't know. She was the original license applicant, Shannon Smith.
I guess you would still be the applicant because we're back on the transfer hearing.
Yes.
So, and then Mr. Bittner would be the protestant's counsel.
Shannon Smith on behalf of S&S Business Inc.
Yes, good evening, Richard Bittner, BITTNER, on behalf of Daniel Stewart, the principal opponent. We do have some other opponents here to the transfer. If I'd just ask them to be identified and sworn at the appropriate time.
So procedurally, I've discussed this with the board, and as council are both aware, the issue that was sent back on the remand is whether or not there was a valid license to transfer. Hearing was taken previously, evidence was taken as to fitness of the applicant. It's the board's position that that issue has been decided. So the only issue is, again, the validity of the license to be transferred. And I forwarded to both council a copy of an order granting injunction dated April 26, 2024, issued by the Circuit Court for Anne Arundel County in case C02 CV 24001057. That provides on the first paragraph on the second page, ordered that the defendant board is hereby enjoined and ordered to accept and process the renewal application for the liquor license in lieu of a good standing certificate, workers' compensation insurance, and sales and use tax license, provided that the said application is complete, otherwise complies with Maryland law, and is submitted on or before May 1, 2024, and all fees are paid, and goes on to include additional conditions. The copy of that is in the board's record, and it's been provided to council in advance of the hearing to make sure that you're aware that this is an area of concern for the board. So procedurally, I think what we have in mind is to hear from both attorneys as to the legal effect of that order, whether or not it in fact negates any defects in the license that may have existed prior to the issuance of the order, or if those issues remain outstanding, in which case evidence could be taken on as to any issues that arose before that, as I know which Mr. Bittner's position is that the license was void as a result of actions prior to that date. So I think the plan is, and the chairman can correct me if I'm misstating, is to take argument of counsel on the issue of the net effect of the license, and then determine at that point in time whether to take additional testimony at this time or hold the matter for a written opinion as to that issue. And then I believe the next step would be is to at least build the record. If the decision of the board is that the transfer is approved and this negates any concerns raised that arise prior to the date of the order, I would still allow counsel to enter documents into evidence to build the record and provide a proffer as to their respective positions on what would have otherwise been presented, so that there was at least a record in that regard in the event there's a subsequent petition for judicial review, or in the event that there's a decision that the order does not negate the evidence that I believe Mr. Bittner intends to present, then the case could be continued and further evidence developed at that time. Is that a correct statement of what we discussed?
Yes, it is.
Mr. Chairman?
Yes.
So with that, I guess, yes, Mr. Bittner, sir.
If I may, just for the record, voice my objection to that. We're here on a remand of a transfer hearing, so I believe the burden is on the transferee to prove the elements that they're eligible to hold the license, included pursuant to Judge Jackson Stevens' order, whether or not a license exists. So I think they are the moving party. They go first. They have to meet all of those elements. They have to show that there's a license in existence and that Ms. Smith is an otherwise fit and qualified person. There was a hearing almost a year, almost a year ago. So I don't know if circumstances have changed, whether she still qualifies.
Certainly, and that does raise an interesting, a good point. So, Mr. Bittner, I agree with you in terms of the burden. So in terms of being heard on the effect of the order, I would hear from Mr. First. Also, I believe you do raise a good point with regard to any change in circumstances that there may have been. So I would ask Mr. to indicate whether or not there has been, with regard to any of the evidence that was presented previously as to fitness of the applicant, whether there's been any material change in circumstances since the the prior hearing date when the testimony as to fitness of the applicant was presented.
So, Mr. Kovay and Mr. Chairman, members of the board, let me first respond to Mr. Bittner's position. I disagree with him. This is a very limited remand. The circuit court judge specifically remanded only for the board to consider the validity of the license. There's no issue with regard to consideration of any further fitness of the applicant. I will proffer to you that there have been no changes with regard to her fitness in that regard. She's never been convicted of a felony or any crimes or anything like. And she has not been able to operate this business because of the pendency of these various appeals. So there's nothing she could do as far as a licensee that might indicate to the board that she wouldn't be an appropriate person to hold a license or continue to hold a license. This is a very limited issue. Was this license valid at the time that the board approved the transfer? And I would suggest to you that the court's order of April 26, 2024, the circuit court's order, is dispositive of the whole issue. Mr. Bittner's arguments with regard to everything else is moot because of this. I have 5 additional copies if the board needs them. Be happy to do that. Mr. Bittner, do you need another copy?
Of the 24 order?
Yes.
No, thank you. Have it.
I think, obviously, Mr. Kovahay read express language of that. It, in fact, addresses any of the issues that Mr. Bittner has raised in his prior arguments. On knowledge and belief, the circuit court judge on this appeal was not aware of this pre-existing order. I'm not sure whether Mr. Kovahay was. I'll have to defer to him on that. I was not, frankly, aware of this until very recently. I understand it's been in the board's file, but I don't know whether it was even considered by the appellate judge on this most recent appeal.
I will say I don't recall it being part of the record that was sent to the board on the prior remand, and I did not raise it at argument. I represented the board at that hearing and did not raise it as an issue at that time.
I would submit to the board that, in fact, if the judge had this to consider, the decision might have been completely different. This is absolutely dispositive, and no other issue should arise at this time. Including the fitness of the applicant, which again, and I'm happy to put on testimony from her today, maybe we should do that so she can testify under oath that no circumstances have changed. This makes it explicitly clear that those various issues having to do with the status of the transferor, including workers' compensation, sales and use tax license, good standing certificates, etc., are not necessary. In fact, the court has specifically waived the necessity for the license to be renewed, and it was renewed, and it was complied with. As a matter of fact, the counsel at that time for my client was Mr. Hurdle, and he in fact filed the renewal application timely, and it did satisfy the court's order that it was in fact filed and acted upon by the board on or before May 20, 2024. And because of that, this is a valid license. It was valid at the time that the board ruled on the transfer, and it's valid today. I'd like to take some testimony, if I may, from Ms. Smith. Have you been sworn, Ms. Smith?
She's not.
Okay, would you please stand?
But before that, if I may have a brief opening statement.
Certainly.
Thank you. So most respectfully, Mr. Chairman, members of the board, we're here before you truly, I think in what everyone would agree is a case of first impression for the board under some very unique circumstances. There simply, most respectfully, is no license to transfer here. The board, the court's order from April of 2024, read in its entirety, viewed with its qualifying requirements, does not cure any defects after the issuance of the order, and it doesn't cure any material defects that were in existence with this license before the order. And most respectfully, the order provided simply that the board would accept the renewal application without the prerequisites normally required of a certificate of good standing for the transferor's business, workers' compensation, and a valid sales and use tax license. So that's what the order provided. The order provided that the board would accept that renewal. The order further provided that Ms. Smith could hold the license without operating, pending meeting all other legal requirements. And then, upon meeting all other legal requirements, there could be a transfer. Now, what I believe we'll show you in the documents, and I move in, we filed the exhibits, we filed them beforehand, we provided you the requisite copies. And I believe what the documents in the record will show, first off, there's no privity of contract between Shannon Smith and Paige Blair, the licensee. There's no contract of sale between Paige Blair selling the license in the business to Ms. Smith. There's no power of attorney from Paige Blair authorizing Ms. Smith to act on behalf of Blair's London Town Pub and Grill LLC, the transferor. So there's no relationship here. Then we have, and the board will look.
I'm going to object to this because it was not raised at the original transfer hearing, which it had to be to get standing in that regard.
Well, it most certainly was raised by Mr. Stewart at the original hearing, and whatever happened at the original hearing really doesn't matter because the court has ordered this back for a remand for a new hearing on the question of whether or not there was a license. And there was testimony taken at the original hearing in any event that Blair's London Town Pub LLC did not exist. And that's why
I'm
the
going to
court
overrule
sent
your
it back.
objection, Mr. Mister.
And this is an opening statement anyway. Thank you. Now, what I believe you'll see further is a series of fraudulent applications made in an attempt to transfer this license into Ms. Smith's name, Ms. Smith's entity. And that starts back in 2021, and we'll get to those documents in a moment. You'll also see that it is impossible, legally impossible, I suggest most respectfully, at this time for we contend the Blair LLC license is expired and it's lapsed. And I'll get more into that in a second. But even if you were to somehow find that the license hasn't lapsed, it's a legal impossibility for that license to ever be transferred to Ms. Smith because the entity, the LLC behind Ms. Blair, Paige Blair, and the license hasn't existed since at least 2023. And you'll see the documents from the comptroller's office that Blair's London Town LLC forfeited their charter, hasn't filed personal property taxes in 6 years, doesn't have a tax ID number, doesn't have any indicia of corporate continuity. Then, so for those reasons, there's no license in existence and the transfer should be denied. But further than that, you'll hear testimony and you know that this establishment hasn't been open and actively engaged in the sales, plural, that's what the code says, 18207, 11-1805, excuse me, and Rule 2.11b, that the establishment must be actively engaged in the sales, plural, of alcoholic beverages. There's been, I expect, there'll be proffered that there was a controlled sale in 2024, and there was a controlled sale in 2025. No controlled sales I'm aware of, or any activity in 2022 or 2023. So the license would have lapsed at that point. Court wouldn't have had the authority to do what it did if the court had known the totality of the circumstances. Controlled sale 2024 purportedly, as I understand it, pursuant to the court's order, circuit court's order from April of 2024, controlled sale in 2025 without any court order. Without any court order. Ms. Smith applied for order allowing for a controlled sale in 2025. That was never granted. Though somehow a purported sale took place. But again, it's not a sale because there was no remission of the sales tax collected at that sale by the documents they submitted to your file. 49 cents was never remitted to the controller because it can't be remitted to the controller because the sale would have been under Blair London Town LLC, which no longer exists. So all of those reasons give the board grounds to deny the license. But equal to that is there's simply no provision. We've all seen it. We've all heard the practice. A controlled sale, have one sale. It allows the license to be renewed and continued. There's no authority for that. There's no rule permitting that. There's no statute permitting that. In fact, the enabling statutes 11805, keep stating that, and 2.11 speak to actively engage in the sales. If the legislature or prior boards wanted to create a mechanism for one controlled sale to keep a license alive, they could have easily added it to the rules. The legislature could have easily added it under paragraph 3, the exceptions that have been provided if the establishment suffers a calamity, they're trying to rehab it, the board can allow the license to continue. There's no Part 3 provision for what they're trying to do here. Have a business that's been shuttered and closed for 5 years, the entity behind the establishment dissolved for some 3 years to try to revive it. So thank you very much. We'll proceed to evidence.
I have a brief reply to Mr. Bittner's position. It's my position that those provisions, even with regard to controlled sales, even though they occurred, were not necessary. You're talking about a situation where you have an existing license that just stops doing business. In this case, where there is an application pending, it stays the ruling of all that. The pendency of an application stays the ruling of the expiration rule. And therefore, controlled purchase is not even necessary. There was a pending application the entire time. And since the approval, by the way, of this board on the transfer, this has constantly been under appeal. Initially for the appeal of the transfer that the board approved. And then secondarily, when we had a hearing last year on the renewal, protest of the renewal license, there was an appeal of that, which subsequently was dismissed, but there was an appeal of that. All of those things have prevented any business operation whatsoever. And we're still here today trying to determine whether my client can go into business as the board had permitted. I contend that the controlled sales were not even necessary. If Mr. Bittner can take the position it's not authorized, but this board by practice has recognized it for years, as do many other of the agencies throughout the state. I think it's because, frankly, boards have realized that the statutory provision, which is most common in most jurisdictions, holding that a license expires by operation of law 10 days after a license holder is evicted or they vacate the premises, extendable only for additional 20 days to a total of 30 days, is inequitable and unfair. And a matter of fact, I just, for information, would point out to this board that several other jurisdictions have changed that statute. Baltimore County, for one, where they allow hardship extensions of licenses up to 2 years. Baltimore City, where they allow hardship extensions of licenses up to a year, 360 days. So, having said that, again, this should not be a total rehearing. It's not to be a total rehearing. Many of these things Mr. Bittner's client could have brought up and should have brought up at the transfer hearing. They did not. If they didn't preserve them for purposes of the appeal. They don't preserve them for going forward now. And so those things, according to Mr. Bittner, were in existence at the time of the hearing. It could have been brought out, in fact, by the protestant, but they were not. The other thing I would point out that I think is very important for the record, this order of April 2024 was never appealed. Was never appealed by the protestants or anyone. So it's can't be reviewed at this point in time or subject to being set aside. I'm happy at this point in time to take some testimony from my client if the board wants to hear it on those issues, unless the board's prepared to give a preliminary ruling at this point in time with regard to my motion that this order of April 2024 is dispositive.
Well, first of all, were you offering the order into evidence as in one of your exhibits?
Yes.
Okay. Make that applicant exhibit 1 for the purpose of this hearing. Okay. And I think, at a minimum for now, let's go ahead and put on testimony as to any change in circumstances to fitness of the applicant, then we consider where we go from there.
Well, okay, and I have some other things that if the board wants to go into it, that I would have my client respond to with regard to some of the other issues that Mr. Bittner's raised. Ms. Smith, you have been sworn to testify. The board
She's not been sworn in yet.
Oh, I'm sorry.
Sorry. Ms. Smith, can you please stand and raise your right hand, please? You solemnly swear and affirm under the penalty of perjury the testimony you're about to give is the whole truth, the whole truth, and nothing but the truth.
Yes.
All right. Please be seated and state your name and address for the record.
Shannon Smith, 3951 Patuxent River Road, Harwood, Maryland, 20776.
Now, Ms. Smith, I was not your counsel at the time, Mr. Hurdle was, but you had a hearing before this board, I believe, in November of 2024, is that correct? Or was it November? Yes, 2025?
24.
2024, right, that's right. And at that point in time, you gave certain testimony before the board with regard to your fitness as an applicant to hold an alcoholic beverages license. And that included the fact that you had no criminal record whatsoever and that you've been a business person for a number of years. Is that correct?
Yes.
What is your other business that you're involved in?
I have I have my real estate license. I have an accounting company. I'm an EA, and I'm licensed in every state for mortgages.
Okay. And since the time of that hearing in November of 2024, when the board found you to be a fit and proper applicant to hold an alcoholic beverages license, has anything happened in your personal or business life that's affected your reputation or your fitness to hold an alcoholic beverages license?
No.
Have you been convicted of a felony?
No.
Have you convicted of a crime of any time other than a minor traffic violation?
No.
Okay. Have you at any time had disciplinary action taken against you with regard to your various professional licenses?
No.
Okay. And you continue to hold those licenses today that you held at the time of the hearing in November of 2024?
Yes.
Okay. Is there anything that, to your knowledge, that you can share with the board that would affect your fitness to hold an alcoholic beverages license in the state of Maryland?
No.
Okay. Now, Ms. Smith, the protestants' counsel has raised an issue saying that you had no standing, I believe, or you did not have any binding contract to, in fact, purchase the real estate and the business that held, I'm sorry, the real estate and the Class D beer, wine, and liquor alcoholic beverages license that was held by Paige Blair, also known as Paige Malloy, as the London Town Pub and Grill LLC. You've heard that
Yes,
offer or argument by Mr. Bittner.
yes.
Tell the board as to what relationships you had with Paige Blair and subsequently with her husband, Robert Blair, with regard to the formation of the contract to buy their real property and alcoholic beverages license.
So when I went to buy it, I spoke with Paige only. She asked me to talk to her realtor, Ken. I sent over a contract with Paige and Robert Blair. He called Ken.
Who's he? You mean Robert Blair?
No, I'm sorry, Ken, the realtor.
Okay.
Called me, said that Paige had called him, and he does commercial real estate where I do residential, and he was going to draw the contract up. And I said, okay. I still never talked to Robert Blair. I talked to Paige the whole time through everything. So Paige did the...
Did she negotiate the contract with you?
Yes.
Okay.
Yes.
Subsequently, what happened? Who entered into the contract with you?
So it was Robert Blair. Ken took Paige off the contract, but Ken said that Robert and Paige had agreed.
So I have to object to Ken. I understand hearsay, the rules are relaxed, but now she's testifying and contradicting a written document with hearsay. Even under loose rules of administrative hearing, that's not permissible.
I don't think that's accurate. Hearsay is admissible and administrative perceive what weight it has. There's nothing in the rules that say whether it's contradictory or not. The board takes it for what weight it gives it. And we're going to back it up with some written documents.
And I would agree, and I'll overrule the objection.
So subsequently...
So I'm sorry, the answer then was Ken took Paige off the contract.
Yes, Ken took Paige off the contract, and I didn't know that Paige held the liquor license. But Paige was involved with everything, all the way to the day of the sale. She signed the application for the transfer. We did all the paperwork, and the settlement happened, and she called me after the settlement and said that she didn't have to be with the settlement. She didn't understand that. And I said, I don't understand it. I don't know. Talk to your realtor. And I just didn't know. But then from the liquor board, Judy called me and said, this was like the day before the hearing.
Again, objection to what the liquor board.
Sustained.
I'm sorry.
Who are you talking about? Judith Hagner?
Yes.
She spoke to you on the telephone?
Yes.
And what did she tell you?
Objection. She's an agent of the board.
What's the relevance of what she would testify to, Mr. Mister?
I think she was going to talk about how Judy advised her how the application should go forward. Is that correct?
Mm-hmm. Or wouldn't go forward.
Okay.
Overruled. We'll take it for what it may be worth.
Go ahead. You may testify.
So she just said that Paige Blair called her and said that she's not going to sign the final document because I don't even really know because. She just told me that and that hearing would be off.
Were you aware, Ms. Smith, that both Robert Blair and Paige Blair reported to you that they were going through a process of a divorce?
Yes.
Objection.
Overruled.
Okay. And in fact, were you subsequently served with a binding term sheet that between Robert Blair and Paige Blair arising out of their divorce, wherein Paige Blair transferred any all right, title, and interest she would have in the liquor license to her husband, Robert Blair?
Yes,
Is this that document?
yes.
I apologize, I do not have additional copies of this. I've shown it to Mr. Bittner. I submit that it is not signed, however, my client has seen the signed copy. When you went to closing.
Objection.
Yeah,
Most respectful.
hold on, Mr. Chairman, hold on. Yeah, if it's not signed, I know she said she would testify, she's seen the signed copy, but, I mean, right now, it's worth the paper that it's
Okay,
printed on
but
anymore.
it's there, and we're going to follow up with the further test. Subsequently, you went to.
So,
That's transfer orders number 2. Transferees number 2, I believe, for
this would be applicants 2.
Yes.
And it's going to be denied, admissions denied based on Mr. Bittner's objection.
Subsequently, when you went to closing for the property, who attended closing and took all of the proceeds of sale for the real estate and the liquor license?
Robert Blair minus all the real estate taxes and comptroller sales tax and all the other fees that had to be caught up.
And only Robert Blair appeared there, and he took all of the proceeds, net proceeds, is that correct?
I assume that, yes.
Objection to what she assumes moves to strike.
Sustained.
Let's put it this way. Paige Blair was not there. No check was issued to Paige Blair whatsoever. All checks were issued to Robert Blair. Is that correct?
Correct.
How much have you expended in the purchase of this property and additional expenses to improve the property? since the
Objection,
purchase?
relevancy.
Sustained.
Did you, Mr. Bittner has, in his opening statements mentioned, did you participate in 2 controlled sales of alcoholic beverages at the premises?
Yes.
Okay. And one was in 2024 and one 2025? Is that correct? You have to say yes or no.
Yes.
And in fact, on at least one of those occasions, there was someone there, an inspector or whatever, on behalf of the liquor board present at the transaction. Is that
Both
correct? On
occasions.
both occasions. Is that
Yes.
correct? And did you, in fact, remit sales tax from at least one of those purchases?
We did,
You filed a sales tax return with it?
under our company.
Okay.
I'm sorry, under your corporation?
Yes.
Is it true that at the time that you closed on the purchase, and when was that settlement date? Do you recollect?
I think it was June 30th, 2021.
And at that point in time, all of the personal property that was owned by London Town Pub and Grill LLC was in fact disposed of, thrown away.
Yeah.
Is that correct?
Yes.
And the only asset actually that you ended up purchasing from them was the liquor license. Is that correct?
In the property.
Well, the real property's different.
Okay, yes.
All right. So to your knowledge, there was no, there would have been no requirement to file personal property tax returns on their behalf because they did not possess any personal property after the closing in 2021. Is that correct?
Objection calls for a legal conclusion. She's not
I'll overrule it if she knows.
Say that again, please.
After the closing, when you purchased whatever personal property was and threw the rest away, there would have been no basis to file a personal property tax return because none was possessed by Blair's London Town Pub and Grill LLC. Is that accurate?
For me to file or for them?
For them to file.
Yeah, I mean, they wouldn't have to file one with property, yes.
Again, objection to her basis of knowledge.
And as a matter of fact, you've, on behalf of.
Overall, if she knows, if she's speculating, then.
She says yes. And on behalf of your company, you currently, S&S Inc. does not have any business personal property, and you filed annually 0 personal property tax returns. Is that correct?
Yes.
To your recollection, because fortunately I was not at that hearing, these issues that Mr. Bittner's raising, were all these issues raised at the time of the original hearing before the board in November of 2024?
I don't recall.
There was a
any-
substantial amount of testimony about whether that license should be there or would be transferred. Isn't that what the focus of the protestant's testimony was?
Yes.
Okay. Was there any testimony before the board that you were not a fit and proper applicant for a license?
No?
And there was never a contention of that fact, was there?
No.
And is it true that there have not, other than the 2 controlled sales that you've testified about, there have been no sales of alcoholic beverages by Blair's London Town Pub and Grill LLC since the time of your purchase of the liquor license in 2021? Is that correct? There were no retail sales conducted?
No.
Other than those 2 we talked about. And therefore, no retail sales tax would have been generated, would need to be collected or remitted to the state controller. Is that correct?
Yes.
At any time did Paige Blair give you permission to execute documents on her behalf?
Yes.
What, in regard to what?
The application, she gave me the login. She gave me a copy of her signature. She was taking care of her brother who was ill. And she gave me permission to sign it. And I signed it as her name and then my name.
And was that was that the initial renewal applications?
No, she did the initial renewal.
Okay. She actually personally signed the transfer application, correct?
Yes.
Okay. Is there anything else that you would like to share with the board at this time before I turn you over for cross-examination by Mr. Bittner?
I don't think so.
Cross-examine Mr.
Bittner.
Thank you. So initially, if I may, we had previously filed on February 26, 23 separate exhibits. I intend to use many of those in my questioning of Ms. Smith, so I'll move in the packet at this time. They've been previously provided to council.
Objection, again, relevance. I think that many of these things are not relevant to the issue for which the circuit court has remanded. They're not circumstances necessarily that were in effect at the time of the board's consideration of the transfer application.
I'm sorry, could you repeat that, Mr. Mister? I apologize.
I just object because I believe a number of these exhibits are not relevant because they were not facts in existence at the time that the board considered the transfer application. Because of that, anything that occurred subsequent to that, it would not be relevant and should not be admitted.
I would agree with that to the extent there's, and I'm not sure how we parse those out to figure out which would be good and bad. But I would agree that if it's essentially remanding back to the original hearing date, I don't think we get to start over in terms of new evidence. Do you want to be heard on that, Mr. Bittner?
Yes, I'd be happy to be heard on that. Indulge me 1 minute.
Certainly.
All of those documents that we seek to introduce were either referenced in the November 12th, 2024 hearing by the opponents to the transfer, or are part of the board's own records and were obtained from the board's own records. So counsel is wrong. This is exactly the evidence that came in. The board did not accept the written documents. I don't believe, I wasn't there at the hearing, but I've got the transcript right here, and I'll put it into evidence for you all to consider if you think this is salient. So there was testimony at the November 12th, 2024 hearing that Blair's LLC charter had been forfeited, that they had no tax ID number, that they hadn't been open since the summer of 2021. And the transcript was presented to Judge Jackson Stevenson, who, when she viewed these discrepancies, felt that it raised...
Objection. It's not in her order.
I believe Mr. Bittner is referring to the remand, if I...
Correct.
But what I'm saying is, he's going to testify what the judge thought.
No, I'm going to testify.
Unless she put it in the order.
She did. She put it in an order. It said the board should consider whether or not there's a license in existence to transfer.
Yeah, but...
And I think that much is accurate.
I think that's it.
And all of these exhibits go right to that question. They've been submitted under the 10-day rule of the board. They're documents that'll be authenticated, either are self-authenticating because they come from Assessment and Taxation's portal, the business entity portal. They come from public government documents that Mr. Stewart has obtained from public records. And they go exactly to what Judge Jackson Stevenson said the board needs to consider in this transfer. Is
Again,
there
I
a
object,
license to
I
transfer?
object to what the judge said.
What she wrote in her order.
That speaks for itself.
Agreed. Mr. Mister, do you have any objection on authentication grounds to any of these exhibits?
You give me a moment, Mr. Covey. I'm going
Certainly,
through them
take your
again.
time. And the reason I ask that is because it kind of gets back to what we talked about at the beginning. If these are things that are mooted by the April order, and a lot of this predates that, but if it comes into if it's considered authentic, I would let it in all likelihood, at least to build the record, subject to whether or not the board gives it any weight, because it may or may not be moot based on the April 2024 order.
it's kind of hard for me to do all this stuff. I will tell you, Exhibit 17, it's not dated. This is purportedly some sort of social media posting by Paige Malloy Blair. It contains no date, other than I guess the date that it was printed out, which obviously is this year. So I don't, I don't know what it's supposed to mean. I mean, as far as what it goes to.
The description says it was from on or about June 2021, announcing the closing of London Town Pub.
Mr. Stewart would testify that he downloaded that in June of 2021.
Okay. And with that foundation, would you have any objection on authenticity grounds, Mr. Mister?
Hold on, Mr. Cavalli, I'm almost done.
Certainly.
Other than some of these things are completely illegible. But when there are things from the board's file, I assume that the board has the original of those. Oh, honestly. I don't know when any of those photos were taken.
Okay.
But I mean, they purport.
The summary says on or about August 12, 2021, which I assume Mr. Stewart would testify to as to the date of those photos. Is that accurate, Mr.?
Correct.
Bittner?
I have no objection otherwise.
Okay. Again, the reason I ask is I'm just trying to streamline. I think a lot of this is to the extent it's public record, speaks for itself and says what it says. I don't think there's a lot of objection to or contest to a lot of the facts that are set forth here. Again, legal issues, whether they may be moot or not, but I'm just trying to keep things a little bit on track to try and make sure we're not here at midnight. So. So I guess we're on, if any other objection? Those are the two I think you had some objection to on, and you're withdrawing those based on the foundation that Mr. Bittner's proffered?
Yes.
Okay. So with that, we would admit 1 through 23 into evidence.
Again, just so it's clear, I renew my objection based upon relevance that those issues are moot in light of the court's order of
Understood,
April
understood, and that's certainly reserved
2024.
based on the argument at the beginning of the hearing. So I think that gets us to your cross, Mr. Bittner.
Thank you. Ms. Smith, as I understood your testimony, and correct me if I'm wrong, you don't have any written document from Paige Blair, a contract, an asset purchase agreement, a note on the back of a napkin where she's agreed to sell or transfer you the business known as Blair's London Town Pub and Grill LLC and the liquor license associated with it.
I do.
You have it with you?
No, I don't. I didn't know that I needed it, but there was an original contract with her. And I also have all the text from her.
And you so that's not responsive. I'll move to strike that.
Yeah, it's not, it's responsive.
I'm
exactly.
going to overrule the objection. I mean, there is response, which says what she has.
Right. Ms. Hagner, the former administrator of the liquor board, told you that Paige Blair was not going to sign the final documents of transfer. That was your testimony, correct?
Yes.
Now, you made reference that you did have a contract of sale for the realty. Contract of sale with Robert Blair.
Yes, and it had the liquor license in it too.
Okay. All right, so let's take a look at that. That would be exhibit number 14, Mr. Chairman, members of the board. Have a moment.
Maybe 13, maybe, Mr. Bittner? 14 looks to be a deed.
Hold on one second.
Maybe I'm missing some exhibits here. Let's see.
So, number 14, let me rephrase that question, my apologies. Exhibit number 14, you indicated you had a contract of sale to purchase 726 London Town Road. Is that right?
And the liquor license.
Okay. And the sale of the real property at London Town Road, you received a deed on or about June the 22nd, transferring the real property to you. Is that right?
If that's the actual date, yes.
Okay.
On or about, yes.
So council has a copy of exhibit number 14, which is the deed. The actual deed. Need me to show you, or does Mr.
I've got it. We have it.
And that deed reflects that S&S Business Incorporated purchased 726 London Town Road, Edgewater, the real property subject of Class D license, and that S&S Business purchased it from Robert W. Blair. Page 1 of the deed.
Speaks for itself.
Is that right? Is that what it says?
Speaks for itself.
Okay. So nowhere on that document does it reference a page Blair was part of the contract of sale for the real property, correct?
Correct.
Now, I'll show you, but I'll ask.
No, I object to that because the deed just references who the transferor is. It doesn't speak to what the contract said. So you have to go to the actual contract.
Okay. Well, I would disagree most respectfully with counsel's
And I'm
characterization.
gonna
A deed
overrule
shows
you
who
can
the
see.
owners are.
Right, but
Okay.
it doesn't speak to what the contract says. The deed is the
So-
deed.
So let me show you what is titled Purchase and Sale Agreement. This was a document that was filed with the Circuit Court for Anne Arundel County, April the 25th, 2024, as part of your pleadings to obtain the court order, exhibit number 1 that was introduced.
Are you referring to the one dated 19 February 2021?
Yes.
Okay. All right.
Yes.
We have a copy.
Okay, have a copy. And, Mr. Minister, I ask for simplicity, if perhaps you could show that to Ms. Smith.
Right here. She has it.
Okay, this is the purchase and sale agreement that you referenced in your direct testimony, correct?
This is the second one.
Okay, and this is the one that allowed the consummation of the deal and the transfer of the land to you on June the 22nd in Exhibit 14, correct?
Sorry, go ahead.
Yeah.
Say that again, Mr. I was asking her a question.
This document that you've been shown, I'm going to ask it's Exhibit 24, marked and admitted as Exhibit number 24. This is the final version of the purchase and sale agreement between you and Robert Blair for the sale of the real property at 726 London Town Road.
No.
Can I interject, Mr. Bittner? To the extent that we're talking about the sale of the property, what is the relevance of the sale of the property?
Okay.
I understand that, because if ultimately the property is transferred to her and she's the record owner of a fee simple interest, I'm not sure
Sale
how
of
we
the
could.
real property, it's not the sale of the business. There's no document that you will see that Ms. Smith can advance that shows that Paige Blair entered into a binding legal agreement to transfer the license to her. The agreement that she referenced, I'm questioning her on now, Paige Blair is not a party to.
And that's dealing, and is that as to property and the business?
It does not reference the business.
And I'm not sure what the relevance is if it doesn't reference the business.
Well, the relevance is that if Paige Blair hasn't entered into an agreement to sell the business to Shannon Smith has no standing to seek a transfer of the business.
That's the business. You're dealing with the property. I'm not sure I don't see the connection directly.
So if you indulge me a minute, because her testimony was that the contract included the sale of the business. The contract does not include the sale of the business.
Might I just point out, Mr. Beer, why don't we cut to the chase here? Your own Exhibit 13 refers to the liquor license.
Right, I'm going to get to that in a minute.
Okay,
And
well,
exhibit number
all right.
13, if I can proffer to the board, is not signed by Paige Blair. So turning back to what would be exhibit number 24.
So let me also again object for the record. This protestant has no standing to challenge this whatsoever. If anybody wants to challenge whether or not Robert Blair had the right to sell the asset or transfer it, it's got to be Paige Blair. She's nowhere to be there. She signed the application to transfer the license in the board's file.
Well, most respectfully, we'll get to that in just a moment, whether she did or she didn't. She's not here to authenticate her signature. She's not here to
It's notarized.
say
It's notarized in the board's file.
that Paige Blair is a stranger to this transaction. Pure and simple, Mr. Chairman, members of the board. There's no privity, there's no contract that Paige Blair executed.
Well, I'm
no
going to object to
power.
this because Mr. Bittner can't offer any testimony from Paige Blair
So,
either.
you're right,
So
I'm
it's
in
all
closing.
hearsay. It's speculation on his part.
So let me
Adam,
turn back to
I'm
20.
inclined to agree with Mr. on this because
He is right.
so
I'm arguing, and I'll move
that's
on.
fine. Because my jumping ahead, did Paige Blair ultimately sign the transfer application?
Purportedly.
Okay. Because you could have the sale of the liquor license could be on a handshake. There's nothing that says it has to be in writing. There's no statute of frauds regarding the sale of a liquor license that would require a written contract to support the transfer.
So
I'm just trying to make sure.
I hear your comment, and if I may continue my inquiry.
Yes, absolutely.
So, Ms. Smith, what's marked as exhibit number 24. Is this do we take a look at it?
Okay.
Is this the contract that you referred to in your direct testimony for the purchase of what you believed was the purchase of the realty and the business?
Yes, it's the second contract.
Okay.
Because we had one before that.
Okay. And this superseded that contract?
And there's a third, yes.
There's a third contract?
Mm-hmm. A reinstatement, I
So I'm going to
apologize.
move in what would be number 24. Now, you made reference to a restatement of a contract. That's exhibit number 13. You have that in front of you?
Yes.
Okay. That restatement is an amendment to the contract of sale from February the 19th, and then another one from April the 15th. Just one copy, because I didn't expect to put it in until I heard the testimony. Now, exhibit 13, the amendment to the contract.
Mr. Britton, just to clarify, I assume I know the answer to this. There's highlighting on this. I assume that's your highlighting. It's not on the original.
this is what I got, and where I got it, I don't know.
The other reason I ask is just for the making of the record, I want to just clarify that
Well,
any
so
yellow
let me
highlighting is
ask, let me
not.
inquire. Ms.
We
Smith,
we would proffer to the board that the original was not highlighted.
Very well.
but is this document, exhibit number 14th, except for the highlight, a true and accurate copy of the restatement and agreement that you referenced in your direct testimony? And it's already been admitted, that agreement does not involve Paige Blair, correct? She's not a signator to the agreement.
Right.
The agreement purports to grant you, through Robert Blair, a transfer of the liquor license, correct?
Correct.
And it purports that Robert Blair grants you the right to operate the business and transfer the business for 12 months after settlement. Correct?
Yeah, yes.
Again, you don't have any written documentation from Paige Blair where she agreed to sell the business to you.
I do. I have.
You just don't have it with you.
Right,
Well,
correct.
I understand.
I didn't
And
know I
again,
needed it.
Objection for the
Now-
record. Again, the protestant has no standing to challenge this. The legal challenge would have to be brought up by Paige Blair and should have been brought before this board. When she knew the application had been filed, she signed the application. She did not appear to protest. She's never objected, and to this day has never objected
That's
to the
not correct.
transaction.
Most respectfully, that's not correct. She sent, and we'll get to that in a moment. You have it in your packet where there's a note that she said she was closing the business. And we have the testimony where the administrator, Ms. Hagner, said Ms. Blair, Paige Blair, was not going to sign the transfer. So you do have that before you. Now, let me show you.
But did she in fact sign the transfer?
She signed, well, there's a 2021 document that we'll get to in a moment that purportedly has her signature, but that occurred after the real property was transferred. That is.
Well, again, that in terms of the relevance and getting to Mr.'s objection, to me, even though they sort of sold them as a package, the transfer of the real estate to me is separate and apart from the transfer of the license. Whether or not Paige Blair signed
Right,
it.
they didn't sell them as a package. There's no contract between the owner of the business, the London.
Well, maybe I mean that colloquially. I mean, I say as a package, they sold the business, they sold the license. Maybe not a single contract that applied that
Sir,
pertains to
most
both.
respectfully, there is no document. There is, except for.
Well, you say there's no document, but that doesn't necessarily mean there's not a contract.
Except for the uncontroverted, undocumented, unsupported, not uncontroverted, uncorroborated testimony of Ms. Smith, you have nothing. The board has nothing showing privity of contract between Ms. Blair. In fact, at this early juncture of the proceedings, you have testimony that Ms. Blair was not part of it. Even if you accept the contention that she signed a renewal application in 2021, okay, that doesn't show that there was any contract to sell the business, no asset purchase agreement.
But getting back to Mr.'s point that I'm kind of hung up on here is, wouldn't the person who would have to come in and say, wait a minute, I never meant to transfer this business or transfer this license, be Paige Blair and not your client?
So if there's no license and there's no one supporting, no transferor supporting the transfer, there's nothing to come in.
But she signed it, right? She signed the transfer application.
In 2021, and then thereafter, she sent a letter to the board. She sent a note to the board. I'm not pursuing it. I'm closing the business. She put a Facebook post out that I'm closing the business. The business has been closed.
Right.
So the mere filing of a renewal application doesn't indicate that she was selling the business to Shannon Smith. I just think I differ in your characterizations.
Because I think
It's nonsense.
You
It's
and I are having a
nonsensical.
debate. If I may just present and continue with my case, perhaps, I think we've gotten off in the weeds. Because
Again,
haven't had a
I
chance-
object to
Well, I think we've gotten off the
standing
weeds
of his
maybe
client to raise the
more,
issue.
more than necessary, but I think it's on the point that Mr. Whatever may have happened from point A to point B as to who talked to whom, at some point in time, Paige Blair signed a transfer application. It seems to me that if someone's going to come in and
She
say.
signed a renewal.
No, she signed the transfer application, too.
So if someone's going to come in and say this license should have been transferred because I was not a party to it, it seems to me that I agree that should have been her. Whether,
Except this is a public hearing, notice to the public, and the public has standing. The public, under the liquor license regulatory system, has standing. That's why you have protest hearings.
It has
That's
standing
why
to protest,
transfers-
but I don't know that that it would create standing to protest on the grounds that you're saying that the person who owns the license doesn't want to transfer.
Why are we having a public hearing then?
On fitness of the applicant, on whether or not the license is valid.
And any citizen can come in and say, no, this license isn't valid. This license hasn't not been actively, this establishment has not been actively pursuing sales of alcoholic beverages.
And those are different issues as to whether or not there was a written or oral or otherwise contract, in my opinion, between Shannon Smith and Paige Blair. So I think I don't think we're getting anywhere with that. I think if there's other points to raise, I think we move on to that.
So thank you. Let me show you, ma'am, what's been, which I'll ask you marked as exhibit number 25.
Let me see that, please.
That's the settlement sheet that was filed with the proffer, what I'm showing, and ask for identification. It's a copy of the settlement sheet for the sale of the real property that was appended to the April 20, 2024 petition for an injunction. Do you recognize that?
It has no signatures though.
Okay.
So,
This is, it has up in the upper right-hand corner, a time stamp from the Anne Arundel County Circuit Court showing that it was filed with your request for an injunction back in April of 2024. See that?
yeah, I see what it
So
it
this
says
is-
submitted, yeah, submission.
This is a true and accurate copy of the settlement sheet. Do you agree with me on that?
I mean, it's not signed, so the sales price is correct? Is this a final HUD? I don't, or
Ma'am,
CD? I don't know.
You submitted it with your application with the Circuit Court for Anne Arundel County asking
There's
for an
probably
injunction.
another, yeah, so I'm just telling you that's the right sales price, that I know.
Okay. All right, now, you indicated that at closing, Robert Blair received all of the proceeds of the sale. He got the check.
Robert Blair had to pay,
So I'm just asking, is that what you said?
yes,
Okay. And this settlement sheet reflects that Robert Blair, in fact, got the proceeds of the sale, correct?
the $2,000, yes.
Right? It reflects that the seller was Robert Blair,
It does, yes.
not Paige Blair.
But the comptroller sales tax that was paid on that was Paige Blair's.
Okay, now, again, directing your attention back to the second page, there's a line indicating monies were to be paid to the controller, but there's no monies reflecting having been paid, correct? That is blank.
Wait,
Debit.
that, yeah, what is over here? Hold
Yeah,
on,
you're not
there
looking
was
right
sales
column.
tax paid, for sure.
Look in the
sure.
wrong column, Rick.
Thank you, stand corrected. Thereafter, you had no, let me strike that.
Again, objection, again, of irrelevancy, again, his client has no basis to object to this, to challenge it.
And you can have a continuing objection on that, Mr. Mister.
Thank you.
Again, if it's dealing with the settlement of the real estate, I'm not sure what the connection is.
Well, the connection is that Ms. Smith testified that there was a settlement of the business and of the realty, and there's no settlement of the business. The only document reflecting the business is Exhibit 13 that was signed by Mr. Blair, not Miss Blair. And again, there's no closing of the circle here, showing that Miss Blair authorized Mr. Blair to act as her agent. So,
but let me query to the board.
So this goes back, most respectfully, this goes back to the basis and why, besides the plain language and the plain reading of the April 2024 court order, is not dispositive of the case. Because from jump, okay, and you have these documents, you can examine them on your own, but you have the sale of the real property, the closing, the deed, was recorded on September the 22nd, 2021. That's Exhibit 14. That was a sale from Robert of the land, and this is why it's important.
This is
Later
argument.
on,
We're talking about argument in the middle of his.
I mean, I'm not sure where they were supporting, well,
these documents are in.
they're in evidence, I agree.
They're into
but-
evidence and trying to
But we're
streamline.
we're sort of bouncing back and forth between
But I also-
cross-examination and argument. So I think
Query
we're-
here,
Well, I'm just trying to respond to the objections.
$11,384.98 for retail sales tax. Would you agree, Mr. Bittner, that there's no
Well, I don't
retail
answer
sales tax on
questions.
a real estate transaction?
So,
Well, that would seem
You
to
don't
be
get to answer any
redirect at that
questions,
point, if we're getting to that point, but
so
I just feel like we're spending a lot of time on who sold the real estate and/or whether there's a written contract for the business, but at the end of the day, or the license rather, that we have a transfer signed by the licensee. And so that's, I think that seems to me that would cure any issues that you're raising, and B, I'm not sure, I'm inclined to agree with Mr. Mister in terms of standing as to who would be the person who could come in. There's a reason for public hearings, but public hearings aren't open-ended. There's limited issues. And I don't think standing as to whether or not I meant to sell something is something that third parties entitled to raise.
if I may continue.
Yes, of course.
Our documents are in, they speak for themselves, you'll make your own interpretation.
Yes.
Now, you have, it's admitted, exhibit, if you bear with me 1 second, this is the exhibit 19. This is a note purportedly handwritten by Paige Blair, delivered to the liquor board, in the liquor board's file, June the 30th, 2021, that the pub is closed and has been sold.
Well, object.
There.
I object.
It's already in evidence.
But it doesn't matter. You still haven't authenticated.
I thought you withdrew any authentication arguments, Mr. Mister.
If it's from your record.
And it's from the board's, I think it's from the board's file.
I understand it's in the board's file, but still, we don't know whether Paige Blair sent that or not.
Well, and there.
I mean, I admit it's the board's file. It came from the board's file, but there's no testimony here that Paige sent it or what her intention was or anything.
Well, I think that's going to go to weight at this point because we've already admitted in
All right,
evidence.
That's exactly what I mean.
And going to wait, when the board examines these documents, you'll see as a lay person that the purported signatures of Paige Blair on these various documents differs. That there's a material question as to what Paige Blair did or Paige Blair didn't do, and Paige Blair isn't here saying, I want the license transferred to Ms. Smith, and Ms. Smith doesn't have any documents saying, Paige Blair says transfer it to me. So that's why these are relevant. That's why these are relevant. And that's why the April 2024 order limited in scope to only accepting the renewal application for 2024 doesn't cure these defects. Because you have, Mr. Chairman, members of the board, you have a series of material, I suggest, misrepresentations, unexplained filings that should give the board pause regarding this whole transaction, and you should find that the license does not exist and has not existed since 2021. Now, if I may just continue my questioning so I can perfect my record with Ms. Smith.
Yes.
Thank you. Now, Ms. Smith, you took possession of the realty on or about June the 22nd, 2021, correct?
Yes, correct.
And when I say you, it actually wasn't you. It was S&S Incorporated that bought the property.
S&S Business Inc., yes.
The establishment has not been open and actively engaged in the sale of alcoholic beverages since the summer of 2021, correct?
Yes.
Except for the 2 purported controlled sales, the business has not been actively engaged in sales, plural, of alcoholic beverages from 2021 to date, correct?
Yes, but I think there's
Now,
more
in
than
fact,
that.
in
Wait,
fact,
she wasn't finished her answer.
I
it's
think
a yes
there's-
or no answer. A yes or no question, she said yes.
But there's more than 2. There was 4 sales, I guess, between the time.
So it's your testimony that you had 1 controlled sale each year from 2021 to 2025?
Paige did 2, and I did 2.
One sale.
Yes.
Now, are you aware that that Blair's London Town Pub and Grill LLC no longer exists as a corporate entity? Are you aware of that?
Under SDA too. Our federal ID number is still good.
That's your testimony?
Yes.
You don't have any document backing that up here with you today? Right?
No.
Direct the board's attentions to exhibits 1, 6, 8, and 10, indicating that Blair's London Town Pub and Grill LLC articles of organization have been canceled. Exhibit 2, the LLC is not in good standing. Exhibits 3, 4, and 9, that the LLC is closed and the sales and use tax number is not valid. So the purported sales that you made, is it your testimony that they were made under Paige Blair's London Town Pubs LLC?
Yes, it would have been because that's who was carrying the license.
And then do you have documentation that the sales tax for the sale under Blair's LLC was remitted to the controller?
I don't. I'm in tax season, and when this happened, I sent all the docs over this weekend. And they're in the email.
You didn't think it would be important to have the documents showing that you had actually had a consummated sale, that you made a sale and remitted the taxes to the controller?
I didn't even know what this was all about. I thought it was about a transfer, and the last transfer was said, the only thing that matters in a transfer is the fitness of the person. So I thought that this was an appeal on the transfer, and I thought that the only thing that matters, I didn't know that we were going back to the contract. That's why I don't have it.
So I'll move to strike all that as not responsive.
Overruled.
Exhibit number 17, Blair's London Town has not filed any personal property tax forms. Are you aware of that?
I know that they did. I don't know exactly what year because she was in my office and I helped her file 2 years.
I believe you've already testified that the business has not been open since the summer of 2021. That's exhibits 11, 12, 18, 20, 23. Have we stipulated he's going to authenticate those pictures, or do you want testimony?
I'm, David, are we okay with it? Mr. Are we okay with the stipulations to that?
I'm okay with it.
Yes.
Photos show the condition of the establishment from 2021 to date at various times. From the board's records, you have.
Again, I'm going to object on relevance as to what it has to do with whether the license was valid.
Objection noted.
And if I may link that up, why I think it's relevant, you'll decide whether it is, and you'll put whatever weight you want to put on it. But you have, Mr. Chairman, members of the board, been introduced into evidence the renewal transfer application that was filed, purportedly filed. This is exhibits. I asked you to pay particular detail to Exhibit 16, Exhibits 20, 21, and 22. These are documents starting with Exhibit 16. This is the document that purportedly Miss Blair filed to renew the 21-22 license that she filed on June the 30th of 2021. Now, again, I'm trying to synthesize this. The real property closed on June the 22nd. On June the 30th, purportedly Miss Blair filed for a renewal of the application. That application was materially and fraudulently inaccurate because it did not reflect the change of ownership in the real property. Look at it, you see the form. It's not signed by the new owner of the property. The ensuing renewal application.
Objection, because the exhibit, we're talking about Exhibit 16, correct?
Yes.
Take a look at that page. You'll see Paige Blair was the witness, not the signator.
That's right. And there's nothing in there that indicates that the property has been transferred. There's a scribble next to the printed name of Paige Blair's witness. Paige Blair is not here to testify who that signature is. But the property, you know, because it's been admitted, the deed.
Well, why don't you ask a question of the witness? Why don't you ask a question of the witness?
I know you're trying to build, but I suspect I know the answer, so.
Well, so most respectfully, my friend does not get to tell me what questions to ask the witness.
Can I jump in? Ms. Smith, is that your signature?
Yes.
Okay.
Okay, so that is your individual signature.
Yes, this on the bottom. She came to me
Okay,
and said I needed to
ma'am,
sign
I'm just
it.
asking you one question at a time. Is that your individual signature, just yes or no?
Yes.
Okay. And the actual owner of the property on June the 30th of 2021 is S&S Business Incorporated,
Yes.
not you as an individual, correct?
No, I was signing for the company.
Nowhere on that document does it reflect that you're signing in your corporate capacity, does it? It's just a scribble of your name.
Right.
Right?
Correct.
Doesn't say on that document that S&S Business Incorporated is the new owner of the real property subject to this license, correct?
No, it doesn't. On the 2 pages, I don't see. I just see my signature.
Exhibit 21. Again, no reflection that the ownership of the property is changed to S&S Business Incorporated. Have the signature page in front of you?
Yes.
Exhibit 22, the renewal application. Miss Page didn't sign that application, did she?
Which one?
Exhibit 22.
22 is,
Direct you to the next to the last page. Looks like this.
that's not 22 that I have. That 22 looks different.
Exhibit 22, renewal application, filed April the,
Mr. Brittany, can you turn or show me what you're looking at, because I think it, to see, make sure it matches up. And the third page is the, with the, looks to be.
Oh, there it is, I've got it, there it is, I'm sorry.
We're all good, okay.
so my question is, Ms. Smith, that is not Paige Blair's signature on that application, correct?
No,
In fact, you testified that you signed it and that you wrote your name next to it.
I did sign it. I had a text from her telling me to sign it because she wasn't around, and I had the password and login to do that.
Okay, thank you for that. You don't have that text here with you, right? Right? Yes or no?
I have it in my phone.
Okay. You testified that when you filed this application, that you signed her name and that you then signed your name next to her name.
And I thought I did. I have.
But you didn't on this document.
On that one, no. But on the.
So, go ahead. On what?
Nothing. Go ahead.
No, finish your answer.
No, I didn't on that.
Okay.
We actually do have the text messages.
This is all this.
Now, when the board initially approved this transfer back in December 2024, it was subject to meeting all legal requirements. You recall that?
Yes.
And that included you obtaining for your new business a trader's license.
Yes.
You haven't done that, have you?
I did. I do. I have one.
You have an-
24, 25, and 26.
You have an occupancy permit for the premises?
No.
You don't have a zoning certificate of use for the premises either, do you?
Correct.
You don't have a health department certificate or a fire department certificate?
Wouldn't those be checklist items, Mr. Bittner?
I'm sorry?
Wouldn't those be just checklist items?
They would be checklist items, but if there's no way to obtain these items because the business has been closed for 5 years and the building under the pictures references in disrepair, and I'll proffer to you, we have Mr. Stewart and 2 other neighbors who would testify to the gross disrepair of the building, that goes to the fact that this license can never be transferred. The license has collapsed, if you would, just like the building. I may have just 1 minute to look over my notes.
Certainly.
Now, are you aware that in February of 2026, the CR tax number for Blair's London Town Pub and Grill, as of and up to February 24th, 2026, the sales and tax use number assigned to Blair's LLC has been invalid?
I am after seeing the documents that you provided.
And you're aware that in fact that number The tax ID number, Exhibit 5, the CR number, that number was closed on February the 28th, 2021.
Based on the text asking the comptroller that question.
The comptroller's records show, and this has been admitted into evidence, the comptroller's records show that the tax ID number associated with Blair's London Town Pub and Grill was closed as of February 28, 2021. Exhibit number 5.
Again, objection. This goes to the.
Noted.
No, but here,
April
so,
20
here's objection, if I
24.
may reply to his objection. Here's the relevancy of that, okay? If the selling entity, the transferor entity, closed its tax ID number, closed its corporate entity, they can't consummate a sale. They can't, even if there is such a rule allowing for a controlled sale. And again, there is no such rule. This is very much akin to what we experienced at the last hearing, where there had been a long established pattern of practice, unwritten, unrecorded, unregulated, that allowed for some type of controlled sale. That controlled sale practice policy contravenes the written state law that says a license has to be actively engaged in the sales, plural, of alcoholic beverages. If the legislature wanted to create such an exemption, they'd have added paragraph 3 at 11805, or the board at some point in one of its iterations would have changed the rule. So there is no authority for the board to undertake a controlled sale. The testimony and the documentation show that the license has not been actively engaged in the sale of business, that the transferring entity does not exist. Circuit Court does not have authority to issue a liquor license. The board cannot issue a liquor license unless the prerequisites are met. Prerequisites have not been met, can never be met. The license is dead. That's my closing argument. Thank you very much. Proffer, Mr. Stewart.
Yes.
And that's my closing argument. I'm not going to say any more, but I just want to see if the witnesses want to say something. Mrs. State your name. You've already been sworn.
No, he's not been sworn in yet. He needs to be sworn.
Well, I object.
I mean,
He has no relevant facts having to do with the validity of the license.
well, let me actually backtrack too, because I think mixed in with all of that was cross-examination of Ms. Smith. So I think Mr. if he has any redirect, that would be the time for that. And then coming back to witnesses, I mean, if it's going to just be a matter of saying business wasn't opened, it was in a state of disrepair, there's photographs to document that, I think everything sort of speaks for itself, and you can just proffer that would be what the testimony would be. But
So
for now, I think we're back to
I
Mr.
do
first,
have
then we'll
some-
come back to that.
Find that text. I know, but I don't think the board wants to see all this. Ms. Smith, you were asked a question by Mr. Bittner about how you were able to access the renewal application online, and you indicated that Paige Blair gave you the password to
Yes.
execute. And do you have a copy of that text there?
Yes.
Please take it out. Let's show it to Mr. Bittner. I apologize, I do not have extra copies of this. We've got about 100 text messages here that you didn't know which would be relevant.
None of this has been provided previously under the.
I think this is a rebuttal. That's
It
the only,
is.
I
It's
think I would
rebuttal.
allow it on that basis.
It's rebuttal. That's the what's this? But I have my exhibit back.
Yes.
So, Smith, when you were asked by Mr. Bittner about if you had any evidence of the text messages from Ms. Blair, you had testified that you in fact had been in contact with her, and she authorized you to go ahead and file the renewal and provided you the password so that you could go online and obtain the renewal application. Is that correct?
Correct.
And the password was Edward James 28 exclamation point. Is that correct?
Correct.
And that's shown that your dialogue with them. I offer these 3 pages of text.
May I have just one?
You offering this in evidence, Mr. Mister?
Yes, please. I don't know.
I don't think you did.
No, I'm offering them now. I just
Yeah.
don't know what my number is at this point in time. Probably 4, maybe.
Right.
Yeah, I offer them cumulative.
Yeah, I understood, so. So I had the order is year 1, the unsigned term sheet is 2, which was not admitted, and I think that's it. I think you're on 3. Unless I'm missing something.
And 3. I have no further redirect of Ms. Smith.
In light of those questions, very brief.
Any objection to the text messages?
Well, I'm going to interpose an objection as to authentication.
Overruled.
Now,
Recross.
thank you. Ms. Smith, as a result of your filing the renewal application for 2025, did you file an action in the Circuit Court for Anne Arundel County seeking an injunction for a controlled sale?
Objection.
Basis?
It's not relevant. This is a question of what the status of whether the license was valid in 2024 at the time that the board considered the transfer application. What's happened subsequent to that is not relevant to this proceeding.
So the relevancy, most respectfully, is that Ms. Smith sought permission of the court in 2025 for some type of acceptance controlled sale, and that permission was never granted. And I have the Maryland MDEC.
The board renewed the license.
Whether that renewal was proper is a question before you based on what Judge Jackson Stevenson remanded to the court. Is there a license to transfer? And I submit to you that without, the license is still in the name of Paige Blair, still in London Town Pub. And if I submit a controlled sale is not permitted under the rules, but if you should find otherwise, there was no controlled sale authorized by the court for 2025. A petition was filed for for injunctive relief, and the case was closed for lack of prosecution. And I'm going to move in as 26. What is left is 3 copies. Oh. So I didn't have 7 because it was a rebuttal.
Again, objection. And
I'm
fact
going
is,
to overrule the objection. We'll give it whatever
right,
weight the board
it
believes is
is.
appropriate.
And obviously, the board never objected to the entry of an order.
Well, and how could the board object to an entry in order if material fraud had been perpetrated on the board? If things aren't as they seem, how would the board know? That's why ABC article has a specific rule about misrepresentation, which extends most respectfully, Mr. Chair, members of the board, to candor with the board. This applicant has had no candor with the board. Thought I'd finish with a closing statement.
Let's see, so that was, are you finished with your recross?
Thank you.
And I think he's done his closing statement prematurely, so I can just maybe do mine. I'll make it very brief.
Well, hold on, again, for the record, I think you were going to at least suggest, well, let me just, to save a little time, is the testimony that you're anticipating just going to be as to condition of the property and what
It is,
have
but
you?
I think my client can best articulate it. He lives next door, and he's here at this public hearing, and he'd like to.
Just keep it brief.
Daniel Stewart, 730 London Town Road, Edgewater, Maryland.
Sir, we have to swear you in, so can you please remain standing? Thank you. You solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Thank you. Please be seated.
Mr. Storr, where do you live in relationship to what's been referred to as the London Town Park?
About 12 feet away
And how long have you lived there?
since February of 2020.
And when was the last time that the pub was open for business?
In 2021 was the very last time they were doing carry-out sales for the previous 12 months leading up to that only.
Well, objection as to his basis of knowledge.
Overruled.
You living 12 feet away from the establishment, if it was open for business to the public, would you have seen it, do you believe?
Absolutely.
What else would you like to tell the board?
Objection.
Member of the public here at a public hearing.
But then we're not here at original public hearing. We're here on the issue of remand only.
I believe you can answer the question.
I was here in November 2024 for this transfer hearing. A lot of us were given 2 minutes to speak. The only thing that was considered that night was the fitness.
Objection.
Overruled.
This is the very first time that I'm able to present all of this evidence why this license has been dead since 2021. I personally gave on record in November 2024 for the transfer hearing, but none of it was even considered, and we were all just told it was the fitness of the applicant.
Well, sir, that's not correct. Let me refresh your recollection by having you look at the transcript from your testimony of November the 12th, 2020.
Objection.
Yep. I mean, do we need to go into that level of detail, Mr. Bittner?
Well, I only bring it up because
I'm going to
Counsel
object.
has-
He's going to now coach his witness as to what to say. He
Well,
asked
I
him a question.
remember, continue, Mr. Bittner.
I'm not going to coach my witness, but it's been advanced here that there was no testimony before the board at the November 12, 2024 hearing as to the status of the license. And Mr. Stewart, in fact, testified that the CR number had been forfeited, that the LLC had lost its charter, and he testified about the business not being open. So all of this was before the board, even though the hearing kind of seesawed back and forth about need and what Miss Blair's business plan was going to be.
Kind of unlike what's wound up happening tonight.
Yeah, a lot like it. And what ultimately, though, got into the record.
And so I'm going to object again.
Well,
Now, he's
and I'm going to
testifying
sustain
for
the
his
objection only
client.
because the transcript in the record.
It speaks
and
for
whether
itself.
Well, let me just make this point, Mr. Wood, because I think there was some indication that there was some suggestion that these issues weren't raised at the original hearing. I know from the transcript they were. The transcript speaks for itself in that regard, so I don't think we need to hear additional testimony on that point.
Thank you. We do have two other members of the community here that would like to briefly address it.
I'm
Do
going
we
to
know what, just if you can what you anticipate they're going to testify to?
Chairman, you stated it properly. We were just talking about the state of the property, and it has not been operated for many years. So
Thank you. If you maybe just state your name for the record so it's in the record, sir?
I can if you'd like.
Yes.
Do I need to swear in?
I don't think you necessarily need to be sworn in, just state your name so we can note your presence.
Nils Salveson, 1401 Oak Bluff Road, Edgewater, Maryland.
Thank you, sir.
Thank
Is that everything, Mr. Brenner? So I guess that we've had a lot of closing throughout the course of the hearing. Mr. Bittner is waving his hands indicating he's done. Since you are the applicant, I guess you have the last word in any regard, so, or any respect, so this is your chance.
Mr. Kovey. Again, I reiterate our position that the order granting the injunction on 26 April 2024 is dispositive of this entire matter. I think it renders all of Mr. Bittner's arguments moot. Also, my position is the pendency of the application to transfer the license would not require that there be any controlled sales, because while that's pending, the license does not expire. The whole purpose of doing the controlled sales is to prevent licenses from expiring. However, if the board finds that under your practices that should be done, the board has done that on a regular basis. I think the board can be bound by its historical treatment of such practices. And whether or not there was a existing CR number for the license had been issued, had a CR number, was issued by the board with a CR number at the time. The fact of the matter is there was a sale that was done and the tax was collected. Whether it could be remitted under an expired CR number, I think, does not affect the validity of the license. For all of those reasons, I would ask that the board deny the protestants' objection to the validity of this license, find that this license is in fact valid, and that it can be transferred upon completion of the checklist items. And as I believe Mr. Kovey, you inferred earlier, those things that are checklist items are exactly that. They don't affect the validity of the license at time. There are things that would impact whether the license can, when and if it can be transferred. And in fact, we haven't been able to complete many of those things, and would have frankly been incredibly foolish for my client to go to some of the expense to render the premises to be in a position that they could get a new use and occupancy permit issued if in fact there's no alcoholic beverage license to be used for this property. I think the board can probably take judicial notice of the fact that this property's value is drastically diminished if there is no alcoholic beverage license associated with it. And I will tell you that as a regular matter, I often advise my clients as to be very cautious about how much capital and expenses they incur until they know that they in fact have an approved alcoholic beverage license. And this has not been finally approved because it has consistently been appealed. Thank you for your time. And
Members of the board have any questions based on any of the argument?
No questions.
So as indicated before, I think this is going to be a written opinion matter as opposed to issuing a ruling tonight. We'll try to get to that as expeditiously as we can. Thank you, gentlemen.
If I may just make one final comment in response to that. A business, a licensed establishment cannot be actively engaged in the sale of alcoholic beverages if they don't have a CR number. CR number for Blair's Pub was forfeited in February, was closed out in February of 2021. She closed the business. So no matter, even if you credit that that's her signature and there was some type of authority granted to Ms. Blair to file it, it's invalid because the entity doesn't exist. You can't be engaged in the sale of, actively engaged in the sale of businesses without a tax ID number.
And I know you, we follow, any last word on that?
No.
Thank you, gentlemen. Thank you, Mr.
Thank
Gray,
you.
members of the board, thank you.
Okay, thank you and good night all. This hearing is now adjourned.